All right, folks, let's get going. MJ, call the roll, please.
Mr. Chair, you have a quorum?
Wow, that's a thin quorum. Okay, great. Well, welcome everybody to the last Senate Courts of Justice Committee meeting for this year. Knock on wood. We got some cognates we're going to knock out first. Without the House just adjourned. They're on their way over here, and then we'll get to new bills. And again, we have I think 34 bills in the docket we need to crank through today. So. First of all, we have House Bill 122 by Delegate Sullivan. It is identical to Senate Bill 580 by Delegate Sullivan. It's identical to Senate Bill 580 by Deeds. We need to make a technical amendment to make the bills identical. Is that in the packet?
Yes, Mr. Chair, it's in the packet, and all it is on line 24 after Act. We're just striking the citation.
Okay, Deeds moves and Boyce goes seconds the amendment. All those in favor say aye. Aye. Anybody opposed? No.
Move to report.
Okay, the bill is, okay, it's been moved and seconded. The bill now be reported. This is the one that makes the city of Richmond the default jurisdiction for disputes over project citing, I think, for certain projects. Okay, clerk will open the roll.
Ayes 7, noes 4.
Okay, next up I got House Bill 267 by Delegate Watts, which is similar to Senate Bill 357 by Boysko. This has to do with assault and battery law enforcement officer with new affirmative defense. We need to conform it to Senator Boysko's bill. And there's one additional change in addition to conforming it. Taylor, can you describe to us what that is?
Yes, Mr. Chair. In addition to conforming it to Senator Boysko's bill, it also just adds the affirmative defense may also apply to a person whose behaviors were the result of a neurocognitive disorder, including dementia.
Okay, does everybody understand the additional type of condition that is included in this? Neurocognitive disorder. Okay, Senator Boysko moves, Deeds seconds to conform with that additional change. All those in favor say aye. Aye. Anybody opposed? No. Okay. Now the bills are identical, I think. Okay. Boysko moves, Deeds seconds to report the bill. Clerk will open the roll.
Ayes 7, noes 5.
Great. Next up, I have House Bill 775 by Delegate Herring, which is pretty much similar to my bill, Senate Bill 503, and Senate Bill 539 by Senator Bagby. It has to do with license plate readers. It's my understanding through the grapevine that the patron intends to carry the bill over and have it referred to the Crime Commission. And I would entertain a motion to do that, and if I'm wrong, we can reconsider that.
I'll move to carry the bill over.
Okay, Deeds moves, Carol Foy seconds to carry the bill over to 2025 with a letter from me referring it to the Crime Commission, of which Delegate Herring is the chair. Clerk will open the roll.
Ayes 12, no 0.
Great. Next up on similar cognate kind of stuff, I got House Bill 1496 by Rasul. I'm going to defer on that till he gets here because there are actually some substantive changes that I think he ought to describe. The next one we have up is House Bill 1539 by Delegate Simon. That one is similar to Senate Bill 15 by Favola, but also different. I'm going to take the liberty of explaining it in the absence of Delegate Simon because it was actually my bill last year. And it's part of it is identical, I guess, to Senator Favola's bill, the part about extradition of people engaging in lawful reproductive health care in Virginia. The part that's different is it adds a cause of action to the Virginia Consumer Protection Act for any supplier, any business that sells information about a woman's reproductive or a person's reproductive health care activity or history, so that somebody can sue, for example, if somebody was selling data that would allow you to see whether they're going into an abortion clinic or purchasing birth control, that kind of thing. That's the additional change. It passed this body last year in that identical format, but obviously we've had some changes. Does anybody have any questions about the bill? Doesn't look like it. Is there a motion to report the bill? Okay, Perry moves, Boyce seconds. The bill will be reported as is without amendment. Clerk will open the roll. Okay.
Ayes 7, no 6.
Okay, having done that, I was hoping that some House people might have gotten here by now. They are? Oh, there's one. Henson. Delegate Henson. Come on down. 794.
Yes.
Statutory service of process. It's a Boyd Graves bill.
Yes, sir. It will clean up issues around service of process, specifically relating to out-of-state entities who are served through statutory agents such as the DMV Commissioner, Secretary of the Commonwealth, and the State Corporation Commission. House Bill 794 ensures that civil actions are not dismissed because of administrative delays that are not at no fault of the plaintiff. Additionally, House Bill 794 adds the clerk of the SEC to the code section, ensuring that the clerk of the SEC is treated as the same as other statutory agents. I urge this committee to support the bill.
Okay, does anybody have any questions for Delegate Henson? I know we had some discussion up here about this bill a little earlier.
Mr. Chairman,
Senator Obenstein.
you know, I still don't understand designating the State Corporation Commission. I understand Boyd Graves believes the State Corporation Commission is already designated, so I'm not going to fight it on that. I do think that it helps clear up issues related to delay in getting that certificate to the clerk's office, so service process is going to be affected the day that the State Corporation Commission, the Commissioner of the Department of Motor Vehicles, or the Secretary of Commonwealth receive it. So I think, you know, on balance, it's probably a pretty good idea. I move to report.
Okay, any further discussion? Is there anybody out there opposed to the bill?
If there's anyone online to speak in opposition, raise your hand.
Doesn't look like it. Okay. Senator Obenstein moves. I think Perry seconds that the bill be reported. Clerk will open the roll.
Ayes 15, no 0.
Great. Who's next? Is Davis here? No. Delegate Herring, we already carried over your bill and sent it to the Crime Commission. Did you have any others?
Yes, sir, I do. The Leo waiver, the law enforcement
Okay.
officer.
Oh, I just wanted, yeah, Davis is next in the line. I just wanted you to know we already took care of that one.
Okay.
Yeah,
All good.
but just have it. Davis was here. You have the one we had last week, right?
Yes, sir.
Okay, do we have a substitute on that now?
Well, maybe.
That's ominous. Okay, so 1443.
Yes.
Where are we?
Mr. Chair, ladies and gentlemen of the committee, there was a, I don't know if the council's given it out yet, it was a mention to change contact to threaten in the original.
Right. Remember, we were trying to add threaten to the statute.
But I'm not sure that solves the problem that the courts had in one of the jurisdictions that asked me to bring that.
We can't hear you very well. You may need to step into that microphone.
I said change it from scratch contact and make it threaten was the suggestion.
Say that again.
The suggestion was to take out contact with the juror and make threaten in the original.
Mr. Chair, it would be
All right, Taylor.
it would be on line 11. After intentionally, strike contact and replace that with threaten. So no person shall knowingly and intentionally threaten with the intent to harass or intimidate a juror.
Second.
Okay, Obenstein moves and Deeds seconds, making that amendment. All those in favor say aye. Aye. Anybody opposed? No. Okay. It's been moved. Senator Deeds moves. Boyce seconds. Bill be reported. Clerk will open the roll.
Ayes 15, no 0.
Great. Thank you, Delegate. I think that's your only one, right? Okay, Delegate Kent, you're next up on the list. Your staff got you on the list earlier. Kent. Yep. You got this House Bill 898 DFS lab bill, which I heard had a little heat down in the House. I'm not sure you're going to have the same problems here, but we'll see. What does this one? What does this one do? 898.
So 898 has a lot of technical changes just to update DFS's process, changing some words to add in the ability to do things electronically, ensuring that DFS can perform the test before the court orders the test. It really creates efficiency. It aligns things with the federal DNA database. There are two things specifically that I just wanted to call out. I believe we've spoken to Mr. Benjamin, so I'm aware that things can be edited based on what happened in committee as well. But the two things I wanted just to point out was one regarding privacy, that they're taking out the word, one of the words in there regarding the certificates of analysis to ensure that the allele tables are protected and not allowed to be made public. It would still remain within the court system, and it would allow all those that need to have the data to be given the data, but it doesn't allow it to be made public. So that's really the non-technical change in the bill.
Okay, and Delegate, this is basically an agency bill, right?
Yes, sir.
Okay. Anybody have any questions? The council, it looks like you're wanting to say something.
Yes, Mr. Chairman, we had lengthy discussions with
Yes, sir.
DFS in order to make sure that the bill accommodated what they wanted and did everything correctly. And I believe that DFS is agreeable to striking lines 147 through 160. And then on line 95, inserting at the end of the new language, this language, nothing in this section shall be construed to limit the ability of the parties, adding this language, and the opposing party shall be entitled to a continuance of the proceeding if requested to allow for their inspection.
For inspection?
For their inspection, that's right. And I think with those two changes, everyone's satisfied the bill would be in good shape.
Thank you.
Sir, I have a question, Mr. Chair.
Senator Perry, you have a question?
Can I ask where the language is about whoever will be entitled to a continuance?
Yes, Mr. Chairman, Senator Perry, that would be on line 95. We would remove the period after 187.2 and add, and the opposing party, which would be either the defendant or the Commonwealth, shall be entitled to a continuance of the proceeding if requested to allow for their inspection. And I can explain the reasoning if the committee wants that.
Senator, you need that?
Yeah, I would ask for an explanation. I guess my concern is on, the day before trial or the day of trial, you come in and say, oh, I need some more time to look at this DNA evidence that I've known about for about, a year.
Mr. Chairman, Senator Perry, that was exactly my concern. And so I had originally suggested on line 84, instead of the current 21 days for the notice, requiring that the notice be provided 60 days in advance so that the parties had enough time and would have no excuse for a continuance. But I understand that would upset or frustrate some of the DFS protocols. And so their suggestion was instead we permit a continuance. Let me further explain that what the bill does, currently, whenever DNA notice is given, Mr. Chairman, we also get the profile, the evidentiary profiles. But for some important reasons, DFS is concerned about the availability of those profiles in the public domain, and so those profiles aren't provided, and there will be situations where the attorneys need the profiles in order to go to trial, and that's what the continuance permits, so that they can subpoena ducis tecum, the underlying information.
Okay, Senator Perry, you question answered or no?
I think we're conflating two things, right? What you know, when you know whether there's DNA in a case, whether it's been provided to you is different from the 21-day notice, right? Those are two separate things. They usually happen separate and apart from each other whenever you're preparing for trial. So I think the continuance language is superfluous, quite frankly, because you can always go into court and say, hey, judge, they just provided this evidence to me. I'm not prepared for trial. I'm not effective counsel, and the court will give you a continuance. But we can certainly keep it in there. I just don't think it's necessary.
Okay. Any other questions about Mr. Benjamin's suggestions? Okay, I think Obenshain moved, indeed, second. seconded those suggestions. That was to strike 147 through the balance of the bill and add those words in around, line 95. Okay, all those in favor say aye. Aye. Anybody opposed? Okay. Well, wait a minute. Sorry. Is there anybody out there with any problems with this bill?
If there's anyone online to speak in opposition, raise your hand.
Vaca, Justice Ford, everybody's good? All right. It's been moved and seconded. The bill will be reported. The clerk will open the roll.
Ayes 15, no zero.
Thank you, Mr. Chair.
Okay,
Committee.
bill reports. Okay. Thank you, Delegate. See you next year. Delegate Coiner.
Good afternoon, Mr. Chair.
Good afternoon.
I have HB 653 before you. This bill removes certain offenses from the list of violent offenses. It doesn't substantially change necessarily punishments, but it does change the categorization from violent to nonviolent, which is extremely important to ensure that sentence enhancements are only applied to violent offenses. The offenses that we are removing from the violent crime list are not violent or forceful in nature, and therefore individuals are receiving oftentimes harsher sentences and longer sentences based on it being on the list of violent crimes when they are not violent in nature. Again, I'm not removing them as being a crime, but the category of being violent versus nonviolent is extremely important. This also is extremely helpful as several of these crimes, because they are labeled as violent, prevent you from certain jobs because they're also on the barrier crime list. So this also will help in the process of that as well.
Yeah, Senator Deeds.
I just look at the code sections. Do you have a quick list of the offenses that are being removed from the?
Yes, Mr. Chair. They are, one is breaking and entering not involving a deadly weapon. So it's a misdemeanor. It's just and the rest are drug offenses. So they are all delivery, possession, or selling, nothing of force on that list, the remainder of them.
Okay, hold on. Is anybody out there opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Doesn't look like it. Okay, Senator Bagby moves and somebody aired seconds that we report the bill. Clerk will open the roll.
Senator Jordan. Ayes 9, no 6.
Thank you, Mr.
That's your only one, right? Yeah. Okay, next up I have Williams. I don't see him. No Williams. Lopez. There he is. Okay, Lopez. You've got two. You want to take the word alien out of the code in House Bill 962. Right?
Good afternoon, Mr. Chairman, members of the committee.
It takes the word alien out all over the code, right?
Yes. It
Okay.
simply removes the term illegal alien as it pertains to persons who are not citizens or nationals of the United States and replaces with the synonymous language as appropriate throughout the Code of Virginia.
Got it. All right. Senator Deeds.
Mr. Chair, is this identical to the bill you introduced once before? It did the same thing?
Yes.
Okay. All right. It doesn't otherwise substantively change the law.
No.
Okay. Any questions for Delegate Lopez? Anybody opposed to the bill?
Anybody opposed to the bill?
Okay, is there a motion? Perry moves, Bagby seconds, bill be reported. Clerk will open the roll. Hold on. What? Boysko has a question.
Are we doing 926 or are we doing a different bill? This is
962.
This is Delegate Shin's?
No, 962. Thank you. All right, let's get the right bill up on the screen. There we go. 962. Clerk will open the roll. Thank you, Senator Boysko. All right. Oh, whoops.
Ayes 8, no 6.
Hey, put me down as a yes, MJ.
Ayes 9, no 6.
Thanks.
Your vote will be noted, sir.
Okay. Lopez, 972.
Thank you, Mr. Chairman, members of the committee. Basically, Mr. Chairman, for 972 would do two things. that would help many immigrants who aren't fluent in English or who may not be familiar with American legal proceedings. Non-citizens who plead guilty to a misdemeanor charge may not be aware that they may be potentially running afoul of federal immigration issues and permanent exile, regardless of how many years they spent in the United States, whether they built a family or a life here, or if they otherwise had never had run-ins with the law. This bill would simply do two things. It would prohibit courts from inquiring about the immigration status of a defendant unless their status is relevant to the case. And two, it would require courts to inform defendants of the immigration consequences of convictions and plea deals. This gives defendants a more complete understanding of their situation and arms them with the necessary knowledge to make an informed decision on accepting plea deals. Ultimately, Mr. Chairman, this is about ensuring a fair process that is free of bias where the defendant has a full understanding of the consequences of their decisions. I hope it's the will of the committee to pass the bill.
Delegate, this is pretty much required by U.S. Supreme Court precedent now, isn't it?
I think, yes, the Padilla, U.S. Supreme Court decision, Padilla.
Is there anybody opposed to the bill? OES, Vaca?
Mr. Chairman.
I hear, Perry and then Stewart.
My question is more generally, I went and looked at some other states and they have codified similar language. My concern is really the sort of the language that's being proposed here, that it says like, hey, advise them of their immigration consequences, which could include things like AB, right? We have typically a very like specific plea colloquy that's gone through in my courts that advise someone of their immigration consequences. It's not just, hey, advise them of, quote, there could be immigration consequences, figure out whatever that means. So I went and looked at some of the other states to see what their code language was that they use specifically. And so I would just suggest that we use something that lays out exactly what it is we want the courts to be telling folks, that advises them of what we believe their immigration consequences could be.
Looks like Mr. Benjamin's lights on. No? Okay. Senator, did you have a language you wanted to propose that you found somewhere?
For instance, in D.C., they say if you are not a citizen of the United States, you're advised that a conviction of the offense for which you have been charged may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. That's out of the D.C. code. I would just suggest something that's more formal like that.
Counsel, what's your reaction to that?
Mr. Chairman, I think Senator Perry is right, but I wonder if the solution is to direct OES to develop a rule for a colloquy. I also note that the bill doesn't specify which proceeding. It just says before the start of proceedings. And there are, of course, multiple proceedings in a criminal prosecution.
Okay, so Mr. Benjamin, what I would suggest, I think your approach is probably best. Let OES figure it out. They can go and survey the world and figure it out. That probably gives them more flexibility instead of us chiseling something into the code. Why don't you two go over in the corner and go work on some language, because this is our last meeting, and we're going to go by. Go over in the corner. We're going to.
We're being sent by the corner.
Yeah.
Sent to the corner. There we go.
Yeah.
I think I'm 4 again. It's crazy. There you go. Let's go to the corner. It's a palatial corner over there.
Okay. All right. So we got to keep this train rolling.
All right.
Okay.
Thank you, Mr. Chairman. We'll go to the corner.
Okay. Williams, you missed it when I called you the first time, and I see you've arrived. You have a Boyd Graves bill with a substitute.
Yes, sir.
Boyd
Great
Graves
to be
usually doesn't
here.
have substitutes. So we got 1248.
Now have peace in the valley. I'd ask that we move the substitute.
Okay, Deeds moves, Boyce goes second. The sub, all those in favor of the sub, say aye. Aye. Okay, the sub's before us. 1 second. Simon, we already reported your bill out. I explained it because I had it last year. I don't know if you have another one. I have 4 more. Okay, then hang out. Okay, Williams.
Yeah, I'd like to move
what
the
does this
substitute. Do? Okay, good. The substitute would allow for, I'm going to ask the deferred my time to the individuals or experts on this. Where's Eric Link?
Okay, you want Mr. Ling to explain the sub?
Yes, sir.
Okay.
The substitute was a byproduct of conversations between us and the creditors bar. They had some concerns that were addressed by the addition of LLCs into the language of the bill.
Okay, but I understand how's it different than the original one?
Pardon me, sir?
How's it different than the one Boyd Graves approved? Boyd Graves usually doesn't like changes to their stuff.
I conferred with Boyd Graves.
Okay, what are the changes?
The changes, right, the addition of the LLCs.
Okay, that's it?
Yes, sir.
Okay. All right. All right. Anybody have any issues with this creditors bar? I'm not sure anybody else who would have OES. No? Okay. Anybody got a motion?
Move the report.
Okay, open chain moves. I think it was Perry seconds. Motion to report. Clerk will open the roll.
Senator. Ayes 15, no 0.
Williams, that's your only one, right?
Thank you.
That's your only bill, right?
Yes.
Okay. Reports. Next up, I got Rasul. Is Rasul here? No Rasul. Then I got Shin. Shin back from the... She's back. Cured. Shin, you've got... what do you got?
I've got House Bill 926, Mr. Chairman.
Oh, there it is. 926. Oh, this one might take a while.
You want me to sit around for a little while?
Huh?
Do you want me to sit around for a little while?
Yeah, why don't we try and take some faster ones first? And then I had Delegate Zaire.
Thank you. I know we're in a hurry. I will condense this to just say this bill we're looking at is H.
1217 is before the committee.
1217 would allow victims of any age or mental health status to be searched for using cellular records if there is evidence of criminal activity. As the law currently stands, not all people can benefit from a search by cellular data.
Can benefit from search. So, Doug, where'd this bill come from?
My Campbell County Sheriff asked for this. There was an incident in Campbell County where they feel they could have saved a life had they been able to get the cellular data.
They say it's fine. Work group says nothing wrong with it. Okay. Is there anybody opposed to the bill?
If there's anyone online to speak in
ACLU?
opposition, raise your hand.
No? Nobody? Wow. Okay. Doesn't look like anybody's opposing.
Second.
Yeah, Perry moves, open chain seconds, that the bill be reported. Clerk will open the roll.
Ayes 15, no 0.
Great. And by the way, we never asked you what your favorite food was. It was your first trip here.
I'm sorry?
Next time, yeah. Okay, next up I have Arnold.
Afternoon, Mr. Chairman, members of the committee. Okay. I've got HB 435.
435.
Yes, sir. Mr. Chairman, members of the committee, this bill simply...
Law enforcement officers petition GDC after exposure to bodily fluids. Okay. Right away. Yeah, I've heard about this. I've heard some judges complaining that we need a better process on this.
Yeah, all this does is permit but doesn't mandate a Commonwealth attorney to file a petition on behalf of a law enforcement officer who suffered a blood-borne exposure incident. I don't know about that, Senator Stanley.
Okay, so this is if a law enforcement officer is exposed, the Commonwealth attorney files something to find out if the officer should be worried about something.
Yes, you're deemed to have consented under the law. This is if the person refuses, then the Commonwealth may file it on behalf of the law enforcement officer. This situation arises where you have law enforcement that are 30, 45 minutes away from the courthouse. You got a Commonwealth attorney sitting right there. They can expedite this process.
Okay. Does anybody have any questions for Delegate Arnold? Anybody have any concerns about this bill? Anybody opposed?
If there's anyone online to speak in opposition, raise your hand.
Doesn't look like it. Okay, Peak moves, Stanley seconds. The bill be reported. Clerk will open the roll.
Ayes 15, no 0.
Great.
Thank you, Mr. Chairman, members of the committee.
Thank you, Delegate. Next up, I got, I'm going to go back to Rasul. I forgot I promised Rasul on 1496 that we were going to, I think we were going to conform it to the bill that passed the Senate.
Second.
Huh?
What's the bill that passed the Senate?
We're going to do that and put it in conference. We're going to do that and put it in conference. Okay? Okay, we're going to conform it to the peak bill that passed, and we're going to put it in conference. Okay, so I heard somebody down there moved, and somebody seconded to conform it. All those in favor say aye. Aye. Anybody opposed? Okay, now it's the same as the peak bill we passed at the very last meeting before crossover. Moved and seconded, we report the bill, so it can go to conference. Huh? Still? All right. Okay, it's been moved. The bill be reported and referred to finance, and it'll be heard tomorrow. Clerk will open the roll.
Ayes 15, no zero.
Great. Off to finance. Russell goes. Next up, we have Cordoza. 1146.
Thank you, Mr. Chair. House Bill 1146, in the interest of time, simply adds child abduction to the list of those covered under the address confidentiality program.
The list of what?
Of the statewide address confidentiality program.
Okay. Doesn't look like it does a whole lot. Anybody have any questions for the delegate? No, it's not a big change. It's all. It's just. No. Okay. It's,
generally behave better than
much
difference than John Edwards.
All right, I heard Perry moved a report, and somebody, open chain second, the bill be reported. Clerk will open the roll.
Thank you, Mr. Chair, members of the committee.
All right.
Ayes 15, no zero.
Off you go. Okay, who's next? I got a list. I got a sign-up list. Herring is next on the list. I'm going off the sign-up.
Thank you, Mr. Chair, and I'll try to be as brief as possible. HB 776 deals with the issue that we were having of hard to recruit law enforcement officers. This bill just changes the requirements that someone has to be either a citizen or a person lawfully admitted for permanent residence, have resided in the United States no less than 60 days, which is 5 years, and are both eligible for and have applied for U.S. citizenship. The residency requirements matches the residency requirements that we have for our military police. I think this is, I put it to the committee for your support. DCJS does have citizenship requirement waivers. But the waiver, while the waiver exists, the agencies are hesitant, our local law enforcement agencies are hesitant to rely on it and to really apply for them. And the reason is that they go through the expense of recruiting, training, doing their own background checks, and then the waiver is not granted. This bill does not take away DCJS's, authority to grant waivers. They still...
So we heard a similar bill earlier from Senator McPike that had to do with DACA recipients.
DACA.
This has to do with people who are otherwise lawfully present, not DACA, but they have a visa or green card or whatever, right?
Right, they're legally present and have applied for citizenship.
Yeah, okay. Does everybody understand the bill? Okay, is everybody okay with the bill? DCJS, Virginia Chiefs of Police, everybody's fine with this? Huh? Well, no, but she's not opposed. She's the City of Alexandria. Yeah. Okay, Bagby moves, voice goes seconds. The bill be reported. Clerk will open the roll.
Ayes 9, no 6.
Thank you, Mr.
Delegate Herring, is that your only one?
That's it?
Okay.
Thank you so much. Appreciate it.
All right. Next up, I got Weber. Oh, yeah, Delegate Ballard. All right.
I need to come up with a good comeback on that.
All right. So you're adding J.D. Power Manual to the not a used car guide, which doesn't even exist anymore.
Yep.
And the code currently says you can basically use any guide you want. You just want to make it really clear that J.D. Power is okay.
Yes, sir.
Okay. Okay.
This bill does a lot.
Yeah,
it's transcendental.
This is a big bill.
This is a big bill.
Yeah.
Does it come with a 300-page manual?
All right.
No, it's got a 600-page manual.
All right. Some people down there moved and seconded that the bill be reported. Clerk will open the roll.
All right, thank you.
Ayes
Mr. Chair.
15, no zero.
All right. Congrats, Delegate Ballard. Okay, next up I have, we already covered Coiner, I think. Then I got Cousins. Is Cousins here? There she is. Cousins. This one's a little complicated, folks. You need to listen. This is House Bill 740. It has to do with bifurcation of possession and judgment in an unlawful detainer case. Pay attention.
Okay.
Go ahead, Delegate Cousins.
Thank you, Mr. Chair and members of the committee.
740.
HB 740 will provide defendants, so tenants in eviction cases, with a meaningful opportunity to have their day in court by ending the practice of bifurcation in eviction lawsuits when the tenant contests the amount owed. So under the current code, judges are required to bifurcate eviction cases upon request of the landlord. This separates eviction cases into two trial dates. One for determining possession and rent, which allows the landlord to evict the tenant, and the second for determining how much the tenant actually owes. This interferes with the tenant's right of redemption, as outlined in the Virginia Residential Landlord-Tenant Act, whereby a tenant can pay what they owe and have the eviction case dismissed. HB 740 will end bifurcation in the instances where a tenant contests the amount owed to the landlord, allowing tenants to fully exercise their right of redemption and restoring due process. We did some work on this bill in the House and were able to come to peace in the Valley with all of the stakeholders with the version of the bill that is before you today.
Thank you, Delegate. There's no opposition to it? Like AOBA, the realtors, they're all good now?
Or just neutral on it.
All right. Okay. Boysko moves, Carol Foy seconds. The bill will be reported. Clerk will open the roll. Excuse me.
Ayes 10, noes 5.
Thank you.
Okay, next up I got Carlson, which has an easy one. Is she here? Got it. All right. You're up next. Lopez, you're next. Carlson, you're trying to transfer an easement?
Yes, I have a lot of.
778.
That's correct.
Oh, another one? It's your two?
I have two. I have a really easy one, transferring quick claim property to the Department of Conservation and Recreation, requested that, and then I have a harder one.
Let's do 778 first. Yeah, that transfers some land. Does nobody has a problem with it, right? You haven't heard anything? Okay.
If there's
Open
anyone
chain
online
moves.
to oppose this, raise your hand.
Stewart seconds to report the bill. Clerk will open the roll.
Ayes 15, no 0.
All right, Carlson, what's your other one?
My other one, Chair, is House Bill 455, and I have a substitute. I would like that substitute to be accepted, and if I can, I speak to it.
Yeah, lean into the mic a little bit. Okay, so Deeds moves, Boysko seconds, the sub. All those in favor say aye. Aye. Okay, the sub is now before us to 455. It should be stapled in your pack, I think.
Great. May I speak to the sub?
Sure.
Thank you. So I arrived at the substitute after consultation with a variety of stakeholders, including the judges, prosecutors, and defense attorneys that brought the recommendation originally for the VCJC conference. I also listened to the concerns of the AG's office and checked in with advocacy organizations to make sure they were on board. The substitute carves out fentanyl and its derivatives to make clear that the intention of the bill has never been to not consider fentanyl possession a felony. It also better encapsulates, I believe, the intent of the bill, which is to allow prosecutors the ability, or at least the option, to charge a misdemeanor for residue truthfully and transparently. And it accomplishes by replacing the weight measurement with the word residue and defining that in a way that's in accordance with the controlled substance procedural manner, which is a sample that is too small to be measured.
Right, so basically if you get a certificate of analysis back that says residue, you can only be charged with a misdemeanor unless it's fentanyl.
The prosecutor, upon the prosecutor's motion, they can do a misdemeanor. They
right.
still can do the
Got
felony
it.
if they would like.
So now you can have a misdemeanor cocaine possession if it's residue or...
For only residue.
Right. Got
Fentanyl
it.
has to remain a felony no matter what.
Got it. Okay. No questions? Okay, Senator Perry.
Microphone, please.
Hit the microphone.
The new misdemeanor charge would be possession, unlawful possession of an item containing residue of a controlled substance. That's the new charge.
Yes.
And what did you say about
Senator
fentanyl?
Perry.
What did you say about fentanyl?
Chair Servo, I would reply that that is a carve-out. That does not apply. That will remain under 18.2, 250, and be a felony as a substance 1 and 2 controlled substance. It would remain a felony. They would not have the option to pursue that as a misdemeanor, no matter whether residue or not.
Senator Perry, more questions or?
Sure, I have a question. You carve out fentanyl. There's a number of other, it says isomers, esters, ester salts, blah, blah, salts of isomers. What about things like carfentanil? Is that included under your
So I did
list
that
here?
Chair, I consulted with those in the AG's office to try to get the best encapsulation I could that would cover fentanyl, and this is what we arrived at. And I would still offer that it's permissive. And if I could speak to the purpose of the bill. Beyond what you guys already get.
I think you're in pretty good shape, Delegate. I don't know if you want
Okay, let me not speak anymore then.
Okay.
Mr. Chair.
Hold on,
Mr.
wait.
Chair.
More questions. Delegate Carol Foy. Senator Carol Foy.
Yes, Mr. Chair, question, well, actually speaking to the bill.
Okay. You want to speak to the bill? Okay.
Yes, and I have a motion.
Well, why don't we see if there's any opposition to it? We usually do that first. Vakar, you guys are poised back there. Are you okay?
If there's anyone online to speak in opposition, raise your hand.
Mr. Chairman, Nate Green, Commonwealth's Attorney for the City of Williamsburg, County of James City, here speaking on behalf of the Virginia Criminal Justice Conference, here to answer any questions. The prosecutors and VCJC are in support of this bill.
Okay. Okay.
Yes.
Okay. Nobody's opposed? Okay. Carol Foy, you still want to speak?
No, I have a motion.
Okay. What's your motion?
Move to report.
Hey, Carol Foy moves, others move to report. Clerk will open the roll.
Ayes 14, noes 1.
Great. That's it for you.
That is all for me. Thank you.
See you next year. Okay. Now I got Munden King. Oh, Lopez, come on up. And then Munden King will be after that.
Patrick Hope down there.
He's not on the list. He's not on the list. Lopez, where are we?
Amazing. So, Mr. Chairman, we met with the experts in the back of the corner, and I think we have language that everyone agreed upon.
Okay, is council going to report the language? You got. You going to report some language to us?
Mr. Chairman, yes, a number of the various stakeholders interested in this convened. We felt that instead of turning this over to the Supreme Court to cobble together a solution, we should simply say directly what the patron intends. And so the suggested language would be this: upon arraignment for any criminal offense, the court shall advise the defendant that the prosecution of an offense may have federal immigration and naturalization consequences. There is a tremendous amount of worthwhile sentiment that the judge should go further into what those consequences could be, but the real-life problem is that many times arraignments are conducted individually through video, and requiring a judge to make this additional statement could become very cumbersome and overly time-consuming. So this one statement at least places a defendant on notice of the potential for immigration consequences.
Mr. Chairman, that was...
Okay, Doug Lopez.
No, that was it was a very good conversation where we actually were able to talk about the fact that this was a very short sentence that was simply added to make this notice something that people would be aware of.
Senator Perry's lights on.
Yeah, I would just say this. There is law now that says prior to you pleading in court, you have to be advised. So the court has to take the time to advise you of the immigration consequences. They have to. It doesn't matter if there's 500 people in the courtroom. If you're going to stand up and you're going to plead, they are going to advise you. They have to. Otherwise, your plea is invalid. So I'll be honest with you, I don't really think that it's a great excuse. We don't have enough time.
Well, I sort of agreed with that back in the room, but this is where we got the compromise.
Okay, well, I think it sounds like there's a sense that you're heading in the right direction, but you might not be upon the solution yet. So why don't we take the amendment, do the amendment, get the bill in that posture, and maybe between now and the floor, there might be some additional language, and maybe you need to go to conference. We'll figure it out.
That's fine, Mr. Chairman.
Is everybody? Okay, Deeds moves and Boyce seconds. The amendment read by, or sub, whatever it is, read by council. All those in favor say aye. Aye. Anybody opposed?
Can I ask if it still restricts the court's ability to make an inquiry, or is it just give the warning?
Mr. Chairman, I would answer the senator that it still does restrict the inquiry as well. So it just still does those two things. We just give more specificity as to what the statement is during the initial part of the arraignment.
All right, Mr. Chairman, I'm good with that part, but I would like to know if there are instances, and I see the language says admissible, but might there not be instances when the court needs to do that to make an inquiry?
Yes, Mr. Chairman, I would say
allow it.
Yeah, I'm sorry, Mr. Chairman. I would say to the senator that yes, we do say it's when it says specifically inquire the immigration status unless the status is relevant to the case. So if the status is relevant to the case, then that's the only time then when the inquiry can be made.
I thought it said when it was. I'm sorry,
Senator Stewart.
When it was admissible, and that confuses me a little bit. But might there be, and I don't know the answer to this, so I'm asking people who are smarter than I am. Might there be instances when a judge needed to make that inquiry aside from what is admissible in the case? And should we tie the judge's hands on that? I'm good with the first part of your bill. That's the part I'm struggling with right now.
One solution, just using language I've heard before, it would be to say, unless necessary to the determination of the cause.
Mr. Chairman, that's the same
Senator
thing
Stewart.
as admissible.
No, Mr. Chairman,
Mr.
I think that
Benzer.
could also reach sentencing, for example, or conditions of bond. That would be the cause. And so if an immigration status, Mr. Chairman, is knowing the immigration status is necessary to the determination of the cause, which could be any of those things, then the statute would permit the inquiry. I'm trying to be as broad as possible.
Mr. Chairman, what if
Senator
there's
Stewart.
something? What if there was a federal requirement unrelated to the cause that mandated a judge make some inquiry? That's what I'm trying to say. There could be other things out there that I don't know about, and or should we put a mandate that judges can't do this?
Mr. Chairman?
That's my concern.
Senator Perry has a reaction.
I have never, ever, ever seen a judge inquire into an immigration status, and I cannot think of a single reason why it would be relevant to anything that the court has to decide.
Mr. Chairman, I haven't either. I haven't either, but I don't know everything that judges have to do
And
in
Senator Perry.
every jurisdiction.
Mr. Chairman, I would just suggest, even if the judge wanted to inquire, that individual may well have a Fifth Amendment right to not answer that question.
That's true, too. Listen, the chair's a little uncomfortable about us doing a lot of surgery on this as we go. I think the safest course of action might be to slap a reenactment clause on this so that it's guaranteed to go to conference, so that gives us another 10 days to figure it out. Does anybody else want to do that?
We can do.
Okay, it's been moved and seconded. We also add a reenactment clause to the bill. That way it
Goes to conference.
Go to conference. We have more time to work on it where we're not under as much time pressure.
All right.
Okay? You good with that, patron?
I'm
Okay.
all right.
All those in favor say aye. Aye. Anybody opposed? Okay, now the bill's before us, and it doesn't do anything until we want it to. It's been moved to be reported. Clerk will open the roll.
Thank you, Mr. Chairman, members of the committee, and the clerk staff.
Great. Thank you, Doug Lopez.
Senator
All right.
Obenshain.
Let me see if we have any other easy ones before we start doing hard ones. Hope seems like he thinks he has an
Ayes
easy
9, noes 2, abstentions 4.
Oh, yeah, this is an easy one. 1338.
1338. I've been tinkering with this section of the code for a while now, and I think I now got it right. I do think that these legal notices should be placed at a public place that people can actually see it, and I'd really like us to get to a point one day where we can put it on a website, because that's where the public could actually see some things. Not everyone goes to the courthouse like attorneys do. And so what this bill does is it allows you to post these legal notices on a website and expands it to include any court clerk, sheriff, or commissioner of accounts of the locality posted where such summons will be principal interest near the courthouse, or you can do it on your website. Now, so it's pretty simple language. I think everyone will agree to it. The thing that I want you to consider that this just came to my mind is because I've been tinkering with this over the last couple of years, I went ahead and put a delayed enactment date on this section for 2025. I think now that we've got Peace in the Valley where it's either on the website or in a conspicuous place, that it can go into effect in July of 2024. So that would be the amendment I would ask you to consider, because there's no reason to delay the effective date when we're sort of doing both.
Have you had something drafted or just in concept?
It's concept. It's just the original enactment of this statute is effective July 1, 2025. I should say make it 2024.
Senator Deeds. It would just be to strike on line 12, strike from the parenthetical through the end of the parenthetical to courthouse.
Say that again?
That would be effective January or July 1, 2024, if you just struck that language.
Yeah, Mr. Chair.
Yeah, Sabrina.
I think because what Senator Deeds is pointing out is the catch line of the section, I think we might need to add an enactment clause, just making it that says that that says it's in due course as opposed to 2025, and I think that'll change it. I have to probably double check, but it would probably be an enactment clause instead of, which would then get rid of the effect of July 1st, 2025 on line 12.
Okay. So you're talking about getting rid of the enactment clause? You want to add one?
No.
I don't see an enactment clause.
No,
Madam, Mr. Chair, she's talking about an enactment clause that gets rid of the language I was talking about on line 12, and I would move that amendment.
Okay, it's been moved and seconded. We make that amendment. Anybody, all those in favor, say aye. Aye. Anybody opposed? Okay. All right. Anybody have any problems with this bill that talks about where we post things on courthouses?
Second.
Okay, it's been moved and seconded by Deeds and Stewart and Carol Foy. Clerk, open the roll.
Ayes 15, no zero.
Thank you, Mr. Chairman.
Okay, thank you. Still good hope. All right. Let's see. Okay, I think we're getting down. We don't have many easy ones left. Yeah, I see. Yeah, okay. I think Shin was up on the sign-up list. And then I got Keys, Gamara, Munden, King, Watts, and Clark.
Thank you, Mr. Chairman. Before you, you've got House Bill 926, and I believe there is either amendments or amendments in the nature of a substitute that have been
I
prepared.
think we have line amendments that were prepared for you, delegate.
Sorry, into the mic. Great.
So let's see, 926. Committee will turn to the line amendments. Deeds moves, Boyce seconds. Line amendments to 926. All those in favor say aye. Aye. Anybody opposed? No. Okay.
Thank you, Mr. Chairman.
926.
I think with the line amendments, we might capture some of the concerns that I had heard from some of the members of the committee. And so, sorry, the mask and my voice. I'm going to take my mask off, and I'm going to try to speak loudly, but I am not feeling great. So I apologize in advance and lifetime for that. The line amendments that we're offering now take what was supposed to be an extension of the statute of limitations. The bill, as introduced, was trying to increase the statute of limitations for the creation of unlawful images as well as the dissemination of unlawful images from the creation and dissemination date to the discovery date. Now this amendment narrows that pretty significantly to a place that I think might be more amenable for the members of the committee. Can I answer any questions for you, Mr. Chairman?
Okay, Delia, but basically you're trying to create a new crime under, I guess, with the revenge porn statute for somebody who's in a state of undress so as not to expose the genitals, pubic area, buttocks, or female breasts, but such videographic or still images sexual in nature. We had some concerns in the work group about whether that's constitutional. Because, I mean, some people find a picture of feet in high heels as sexual in nature. I mean, how does that put a person on notice as to what's a crime?
We went, Mr. Chairman, in conversations with counsel on this. Our understanding and our sort of conclusion with counsel and DLS was that it would be constitutional, and they would still have to go through a fact-finding process with the court, and the judge would determine if it was or wasn't sexual in nature. So, like, I guess the answer was like, yes, we would think it was.
I think you're missing the point, though. The defendant, the public is entitled to know what's illegal before they're charged, not after. And so that's the problem with having vague language in a statute. And so how does the public know what is sexual in nature based on reading the statute? That's the problem.
I guess I would interpret that as something being sexual in nature seems pretty obvious, even if it's not defined in nature in code. So that's me. But there were lots of conversations about this, and if there are offerings of definitions in how we can narrow sexual in nature, and I'm certainly open to that.
Well, Doug, I think that the words that have been used in the past that have been constitutionally stood up to constitutional scrutiny is obscene.
Sure, and we understood that obscene would hold a higher standard to meet in court than what we're currently at. So we were trying not to go with the obscene standard.
Well, there's a reason for that. I mean, when I was in law school, I participated in an exercise where we basically took all kinds of pictures out of magazines and art books. We threw it up on a wall, hundreds of pictures, and we said, you know, which should be illegal? And Michelangelo's David, it had all kinds of stuff on it. And it's, you know, it's like Justice Powell said, you know it when you see it, or something like that. I mean, this is why the obscene standard is what we typically use. So it seems to me that if you want a bill that's actually constitutional, you ought to stick with obscene. That's the chair's point of view. I haven't heard anything from the committee about it, but.
Mr. Chairman, might I ask, if we inserted that definition of obscene into this piece of code right now, then would that be the standard for how already existing code also has to be met too then? And like, would we be making it harder under existing code for folks to have to prove that, even if we didn't add this new misdemeanor?
Delegate, I don't understand your question.
Sorry. Could we take this by temporarily, and could I chat with counsel about this specific question? Because I'm not sure that I'm going to...
Mr. Chairman, the answer is no. It would not modify the existing clauses. It would only modify the new clause.
Got it. In that case, Mr. Chairman, I would be okay with adding obscene as the definition for this.
And I also think, Delegate, there was a concern as to what a state of undress is.
I thought we took that out in our amendment, but maybe that did not happen.
No, it did not. No, you only changed the statute of limitations. You didn't change that. So why don't you go with counsel over in the corner, the Lopez corner?
Mr. Chairman, to do that, you would simply say where such videographic or still image is obscene as defined by 18.2-372.
So, counsel, can you read that again?
Beginning on line 14, strike everything after little 3 and insert the word where. Strike it up until the word such on line 15. So it reads, or where such videographic or still image is obscene as defined in -372.
Okay, got it.
But Ms. May says I have flubbed this, so.
No, Mr. Chair, and it just doesn't flow from what's the language right before the clauses. That language is disseminates or sells any videographic or still image created by any means whatsoever that depicts another person who is, and then it picks up. So we might just have to work on the language a little bit, because then that would read who is where such image is obscene. We may just have to reword it.
We can do that.
Okay. So
Then it's
So you guys think you can clean that up? Does the committee understand the proposed amendment? Okay. Can somebody move the amendment? Okay, Bagby moves, Boysko seconds the amendment in concept, which is pretty fleshed out. All those in favor say aye. Aye. Anybody opposed to that amendment? Okay. So now the bill's before us with an amendment on it. Anybody else have any questions for Delegate Shin? All right. Is there anybody out there who is opposed to the bill?
If there's anyone online to speak in opposition, raise your hand.
The pro-revenge porn crowd. Okay. Looks like we got an amended bill. Okay, any further questions? All right. Is there a motion on? Is a motion to report? Is there a second? Is a second. Okay. Clerk will open the roll.
Ayes 9, noes 2, abstentions 4.
That's an interesting vote.
I see it before I support it.
Yeah, got it. Okay. Thank you, Delegate. All right, next up, I got Keys Gamara, who wants to revisit Congressman McClellan's work from 5 years ago.
Good evening, Mr. Chair, members of the committee.
Go ahead, Delegate.
House Bill 994 would take a simple but powerful step to protect all of Virginia's children by making the legal age, minimum age for marriage to be 18. This will accomplish three critical common sense objectives: preventing forced marriages of children, ensuring that both parties to a marriage are fully empowered to protect themselves from abuse, and preventing early marriages that put children at acute risk of immediate and lifelong harm. It is my understanding, I've received quite a bit of information from a number of organizations. This is actually an international effort to change the legal age of marriage, and a number of organizations are in support of this, including NOW, Equality Now, Zonta, Feminist Majority, and so many more, the NAACP, etc. I would ask for passage of this bill and consideration that the committee remove the enactment clause.
Yeah, so I think one of the questions that was raised is, if you can emancipate yourself at age 16, why should you not be able to legally marry?
Well, I think there's a couple of things to say to that. We vote at age 18. We also have a number of statistics that are impacted by young people who are married before 18, including 80% divorce rate, including a much higher rate of exposure to abuse, the inability to be able to make appropriate decisions to be able to protect oneself. So there are a number of reasons. And when we look at the statistics, we are typically looking at very young women marrying older men. And I think as a matter of policy, we want to protect those young people.
Thank you. Oh, wait. We got to take support and opposition. We can't just.
I do have a number of people here who want to testify. I didn't know if you wanted to
I'm
hear
sure there's
from
people
them.
in support. First, I want to see if there's any opposition to the bill.
If there's anyone online to speak in
So why don't we
opposition,
set
raise
it
your
at
hand.
3 and 3 then, if we had opposition? So.
Mr. Chairman, Josh Schutzer on behalf of the Family Foundation. We worked very closely with then Delegate McClellan and Senator Vogel in 2016 to develop this law, and we found a reasonable compromise, and that was, if you're emancipated as an adult, you should be able to make all the decisions pursuant thereto. As far as we know, since that law has gone into effect, on average 8 per year in Virginia are getting married, and they have any number of reasons to do so. Sometimes someone gets pregnant and they want to get married and have that child in marriage. And there are any number of things. We've seen for many generations people get married at 16, 17. It's less common today, but throughout the course of history, there have been people who are mature enough. But in particular, we're talking about people who have all of the legal rights to defend themselves against would-be coercion. And so we think on balance, the way the law is crafted now is a good compromise. It's working, and we ask you to support the current law and reject this bill. Thank you.
Great. Thanks. Anybody else in opposition? Anybody online in opposition?
Mr. Chair, there's no one to speak in opposition at this time.
Okay, can you reset the clock? We'll do those in support. Set for
If there's anyone
2
online to
minutes.
speak in favor of the
2
bill,
minutes,
raise
MJ.
your hand.
You took 1:48. Let's set it 2 minutes.
Thank you, committee members. My name is Casey Swegman. I am with the Tahari Justice Center in Falls Church, Virginia, testifying in support of HB 994 as introduced. I want to just respond really quickly to the emancipation question. When you emancipate in the state of Virginia, you still are not able to vote, to drink, or buy cigarettes. It allots you some rights, but not all rights. We believe marriage is one of those that should wait until 18. The other thing I would like to say is that the status quo is letting the most vulnerable minors slip through the cracks. In 2018, 23 minors married, and all of them were married off to adults. One had a 9-year age gap, and that was approved by a judge. Since 2019, 27 more minors have married, and all of them, again, married adults. These are not Romeo and Juliet situations. The goal was never just a handful of minors married in Virginia every year. The goal was always none. I hope that you will pass this bill. Thank you.
Mr. Chairman, members of the committee, I'm Bridget Combs. I'm a Virginia resident and a child marriage survivor. I support HB 994 as introduced. I was 15 and 7 months pregnant when I stood in front of a judge being married to a 38-year-old man while agreeing this is what I wanted and I was not being coerced. The adults there agreed it was in my best interest. Documents were signed and I was married. It did not matter what I thought about any of it. It didn't matter whether I was 15 or 17 because my parents would have done or had me do whatever was necessary to get me married, including emancipation. With all due respect, does anyone here actually think a vulnerable young person in fear of their parents or even God himself is going to protest? I can tell you when I was the one standing there, I could not. I could not speak up then, but I can speak now, and I will fight tooth and nail for others who are not able to speak. I urge you, please, pass HB 994 as introduced and end any possibility of child marriage in Virginia now. Thank you.
Okay, time's expired. If everybody else could just state the organization you're with and you support.
Lisa Sales with Virginia Now, and we support the bill.
Lourdes Vines, representing Sonta International. Thank you, Chair. We respectfully urge you to approve this bill. Thank you.
Thank you.
Tamer Deganosidze, Equality Now. I testify in support of the bill.
Mariam Torosian, founder of SafeU, I testify to adopt a bill to end child marriages in Virginia.
My name is Federico Cura. I live in Arlington, and as a parent of 2 daughters, I strongly support this bill.
Okay, thank you. Okay. Oh, NAACP support?
Support, thank you.
Great, thanks.
Mr. Chair, we have 5 people online that would like to speak.
Okay, online, you just need to state the organization you're with and you support. Time's expired, and we're really short on time.
Judy Wygand, you may unmute, and please make sure your camera's on.
I'm Dr. Judy Wiegand, and I support the bill. I was a child survivor of marriage from Virginia.
Okay, people online, please make sure you turn on your camera.
Sarah Tasneem, you may unmute.
Hi, my name is Sarah Tasneem, and I am a child marriage survivor, and I support HB 994 to protect minors from abuse of child marriage. Thank you.
Abigail Rittenor, you may unmute, and please make sure your camera's on.
And my name is Abigail Rittenauer. I'm a Virginia resident and the daughter of a child marriage survivor, and I support House Bill 994 as introduced.
Michelle Hanash, you may unmute.
Hello, I'm Michelle Hanash, Director of Policy and Women's Programs for the AHA Foundation, and we are here in strong support of HB 994 to end child marriage. Thank you.
Maria, you may unmute.
My name is Maria. I'm a resident of Virginia who was married in Virginia at the age of 17. I support HB 994 as introduced.
Okay, that's it. Okay, the bill's before us.
Mr. Chair.
Is there a motion?
I move that we remove the reenactment clause and move to report the bill. We know that when we are talking about criminal justice reform and we have people who are minors who were incarcerated when they were teenagers, many of us on this panel have fought to make sure, because their brains are not fully formed. This is an important bill, and I hope that it passes.
Okay, Delegate, why did they put a reenactment clause in your bill in the House?
Initially, I can't really explain that, other than I think that there was some disagreement initially, and they wanted the Senate to have an opportunity to decide whether to remove the clause or not.
Okay. All right, so there's a motion to remove the reenactment clause. Is there a second? It's been moved and seconded. All those in favor say aye. Aye. Is there anybody opposed? Okay. Bagby moves, Aird seconds. The bill will be reported without the reenactment clause. Clerk will open the roll.
Ayes 11, no 0, abstentions 4.
Okay, thank you, Delegate. I think that's your only one, right?
Yes, it is. I got to go over there. Thank you.
Okay, Munden King, then Watts. Go ahead, Doug. Munden King, you got 1542 about mandatory reporting of certain
Yes.
child crimes, sex crimes, I think, right?
Yes. Thank you, Mr. Chair. House Bill 1542 is a bill that adds aggravated sexual battery and attempted rape to the list of mandatory reporting crimes that can have criminal penalties for failure to report. And that's pretty much the bill.
Delegate, I think we have a group of lawyers that look at these things before they hit the committee, and there was some concern amongst that group about how a layperson would determine whether or not an attempt had occurred of one of these types of offenses that would trigger the mandatory reporting. Do you have any reaction to that?
I would say to them, Mr. Chair, that we aren't talking about lay people. We're talking about people who work in careers of care. They're trained to look for the signs and potential issues for abuse. And so while they may need to update what they're looking for, they're not just any person. They're highly trained individuals who have been looking for these types of incidents, especially related to children, for many years.
Okay.
Mr. Chairman.
Yeah, Senator Perry.
I'll just say I agree with the delegate. These are mandatory reporters. They are trained in what it is they're looking for, what it is that would qualify, and what it is that they're supposed to be reporting. It's not just some random person. Is this rape? Is this aggravated sexual battery? Was there a touching? Was there not? That's not what they're doing.
Okay. Any other questions for Delegate Munden King? No other questions. Okay. Is it no opposition to the bill?
If there's anyone online to
Medical
speak in
Society,
opposition, raise your hand.
Nobody else? Nope. Okay. Somebody down there moved to report. Okay. Perry moves. Boyce goes seconds. Report the bill. Clerk, open the roll.
Ayes 14, no 0, abstentions 1.
Thank you, Mr. Chair, for not making me last this time. Good job.
At your service, Delegate. All right. Next, we got Watts, Clark, Simon, and McClure. Simon has 4. I might take him last. Watts.
Do I understand that you've already handled HB 267?
We did. 267's gone.
So
Reported.
I have 2 then before you. I will take HB 266 first, which is custodial interrogation of a child. And 266, I do have a line amendment before I start, and this was requested by the Virginia Association of Commonwealth's Attorneys. A variation had been in a previous version. On line 26, after a law enforcement officer, and please insert the word knowingly before the word violates. The purpose of the line amendment is to make sure that there's no ruse in saying who the parents might have been.
Okay, it's been moved and seconded that we add knowingly before violates on line 26. All those in favor say aye. Anybody opposed? Aye. Anybody opposed? Everybody awake? All right.
And speaking then briefly to the bill, this provision was put in the code, I believe it was in 2021 when I carried it. Interestingly, while it says that you must notify the parent and make sure that the child has that before the interrogation, we have never had a remedy for it. And interestingly, I was contacted in the last 2 weeks by a circuit court judge in Richmond who wrote an extensive opinion about which included the problem that the juvenile had not had the proper notification of the right to talk to the parent, no matter what the juvenile said about their comfort level in speaking further in what turned out to be a 6-hour interrogation. So this then, the purpose of this bill is to put in what you would expect in other circumstances, the remedy that such information would not be admissible.
Okay. Does anybody have any questions for Delegate Watts? No questions. All right. Is there anybody opposed to the bill?
If there's anyone online to speak in opposition, raise your hand.
Vaca, nobody, everybody's good? All right. I think it was Aird. Is that you? Aird moves to report, seconded by Deeds. Clerk will open the roll.
Ayes 15, no zero.
Delegate, you've got one more, 268, and you have a substitute.
I do. I hope you do have the substitute before you.
Okay, Deeds moves, Bagby seconds the substitute for 268. All those in favor say aye. Substitute is now before us.
I can walk
Go
through
ahead.
the substitute,
Fire away.
or
Yep.
the council can. Again, the substitute is after extensive conversations with VACA and other interested parties about just how the processes would move if an individual, in fact, has information about having been sexually abused or trafficked by the alleged victim of the crime. I would just simply walk you through that the existing 16.1, 269.1 has the court shall, on the motion of the attorney for the Commonwealth, hold a transfer hearing, and the court may retain jurisdiction or transfer. And that part of this process, if you'll notice on line 18, is that the court shall, hearing shall be subject to the following conditions. And so the new language that is added adds to a number of conditions that you can see that the court needs to find by a preponderance of the evidence that the juvenile is a proper person to remain within the jurisdiction of the juvenile court. And so what the bill does is add to all of those provisions, provision K, which is any information about whether or not the juvenile was a victim of felonious criminal sexual assault or trafficking. So all of this is in addition to the information that's all part of a report that is prepared for the judge in this consideration. Then on page 3 on line 65, it deals with the situation where you have an individual who is 16 years of age or older and where you have the most serious offenses. In that, on line 69, upon the motion of the juvenile, the court may consider.
Is there any opposition to this bill out there?
Okay, I'm fine.
Do I have a motion? Okay. Motion and a second. Unless there's an alternative motion, please open the roll.
Thank you all who worked on it. Thank you.
Thank you, Delegate Watts. I mean, you are the best.
No.
Senator Salim.
We have 5 minutes left to get just a handful
Senator
of bills.
Senator Dees for Senator
I
Subramaniam.
apologize.
Ayes 15, no zero.
Okay. Folks, I just want to sort of let the committee know where things stand. So we're supposed to be back in the Senate at 4:30. The Speaker advised me that he's going to take the House at ease so the committees can work. Senator Boysko advised me that Jen Laws has what, like 20 bills left or something? Yeah, they got 20 left. We've only got about maybe 6 or 8 here. No, I know, but I think we're going to need at least probably 30 to 45 minutes to knock out what we got left. So talking to Tara, I think we need to recess courts, Jen Laws, go back, take care of the flip-flop, then come back here and finish the committees. I think that's probably the most efficient way to proceed at this point. So, huh?
Yes.
We have to stay on campus. We got to stay on campus.
I saw it.
Okay. So, having said that, committee will rise. No, we'll not rise. We'll recess. We'll recess until 15 minutes after the, 15 minutes after. Okay?
Senator Surville, the senator from Eastern Fairfax County.
Good evening, Madam President. I move to waive reading of the House communication.
The question is, shall the reading of the communication from the House be waived? Those in favor of waiving the reading will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, noes 1.
Ayes 37, noes 1. The reading of the communication from the House of Delegates is waived.
Supplemental calendar. We have a change in conferees on House Bill 355. Conferees now on 355 is named by the chair at Education and Health are Senators Vance Valkenburg, Pekarsky, and Durant. Supplemental calendar number 1, unfinished business Senate Bill 448 is passed the House with a substitute.
Chair recognizes Senator Rouse, the junior senator from Virginia Beach.
Thank you, Madam President. I move that the Senate concur with the House substitute.
And with an explanation, the senator may continue.
Thank you, Madam President. We have essentially adopted identical forms of this bill, the House version and the Senate version. They now are in alignment, and I would move that we concur with the House substitute.
The question is, shall the Senate concur on House substitutes for Senate Bill SB 448? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. The Senate concurs.
Senate Bill 556. The House has passed the bill with amendment.
Chair recognizes Senator Surville, the senator from Eastern Fairfax County.
Thank you, Madam President. With the recommendation that be rejected, I move that we concur with the House amendment and speaking to that motion.
The senator may continue.
Thank you, Madam President. This is the bill to raise the cap on the historic tax credit per taxpayer cap, which right now is set at $5 million. The Senate position is for 10. The House has inched a tiny bit closer to our position at 7.5, but at the end of the day, this is going to have to be a call, I think, that's made in the budget conference. So this bill needs to go into conference with it, and rejecting this will put it in that posture. So I would, again, reiterate that you need to go red on this motion.
The question is, shall the Senate concur with the House amendment with the recommendation that it be rejected? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
0, noes 39.
Ayes 0, noes 39. The substitute is rejected.
Senate Bill 212. The House insists on its substitute and requests a committee of conference.
Senator Rouse, the junior senator from Virginia Beach.
Thank you, Madam President. I move that the Senate accede to the House request for a committee of conference on the bill.
The question is, shall the Senate accede and request respectfully a committee of conference on the bill? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, no 0.
Ayes 39, no 0. The Senate accedes to the request and request a committee of conference on the bill.
Conferees on the part of the Senate is named by the Chair of Commerce and Labor, Senator Deeds, or Senators Rouse, Locke, and Stanley. Senate Bill 550 has insisted on its amendments and requested committee of conference.
Chair recognizes Senator Deeds, the senator from Charlottesville.
Madam President, I move that the Senate accede to the House request for a committee of conference on this bill.
The question is, shall the Senate accede to the request for a committee of conference on Senate Bill 550? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, no 0.
Ayes 39, no 0. The Senate accedes and requests a committee of conference on the bill.
Conferees on the part of the Senate is named by the Chair of Commerce and Labor, Senator Deeds, or Senators Deeds, Lucas, and McDougal. Senate Bill 582, the House insists on its substitute and requests a committee of conference.
Senator Eben, the senator from Alexandria.
I move the Senate accede to the House request for committee of conference on the bill.
The question is, shall the Senate accede to the request for a committee of conference on the bill? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, no 0.
Ayes 39, no 0. The Senate accedes to the request and requests a conference committee.
Conferees on the part of the Senate is named by the Chair of Finance and Appropriations, Senator Lucas, or Senators Eben, Favola, and Pillion. And we are awaiting House action on the next section of bills.
The Senate will be at ease. Senator Surville, the senator from Eastern Fairfax County.
Madam President, I move to waive the reading of the communication of the House of Delegates.
The question is, shall the reading of the communication from the House be waived? Those in favor of waiving the reading will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, noes 2.
Ayes 37, noes 2. The reading of the communication from the House of Delegates is waived.
Unfinished business, Senate. We are awaiting House action on Senate Bill 556. Page 4, your blue calendar. Unfinished business, House. House Bill 14. The House has rejected the Senate substitute.
Senator Deeds, the senator from Charlottesville.
Madam President, I move that the Senate insist on its amendments and respectfully request a committee of conference. Respectfully? I have no respect. Forcefully, that's right. We forcefully request a committee of conference. We forcefully demand a committee of conference.
I can tell that it is late. The question is, shall the Senate insist on its amendment and respectfully request a committee of conference on the bill? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, no 0.
Ayes 39, no 0. The Senate insists on its substitute and respectfully requests a committee of conference on the bill.
House Bill 29. The House has rejected the Senate amendments.
Senator Lucas, the senator from Portsmouth.
Madam President, I move that the Senate insist on its amendments and vehemently request a committee of conference.
Here we go.
The question is, shall the Senate insist on its amendments and request its committee on the bill? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, no 0.
Ayes 39, no 0. The Senate insists and respectfully requests a committee of conference.
House Bill 30. The House has rejected the Senate amendments.
Senator Lucas.
Madam President, I move that the Senate insist on its amendments and vehemently request a committee of conference.
The question is, shall the Senate vehemently insist on its request and respectfully request a committee of conference on the bill? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, no 0.
Ayes 39, no 0. The Senate insists.
House Bill 590. The House has rejected the Senate substitute.
Senator Eben, the senator from Alexandria.
Thank you, Madam President. I move the Senate insist on its substitute and vehemently demand a committee of conference.
The question is, shall the Senate vehemently insist on its substitute and request a committee of conference on the bill? Those in favor favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, no 0. The Senate is vehement.
House Bill 698. The House has accepted the Senate substitute. House Bill 790. The House has rejected the Senate substitute.
Again, Senator Lucas, the senator from Portsmouth.
Madam President, I move that the Senate insist on its amendments and fervently request a committee of conference. I'm gonna use all my F words first.
The question is, shall the Senate insist on its substitute and respectfully request a committee of conference on the bill? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, no 0. The Senate insists.
House Bill 960. The House has rejected the Senate substitute.
Again, Senator Surreville, the senator from Eastern Fairfax County.
Madam President, the chairman of the Finance Committee is pointing me to vehemently demand a committee of, and insist a committee of conference on this historic tax credit bill.
I thought the House was the rebellious one. The question is, shall the Senate insist on its substitute and respectfully request a committee of conference on the bill? All in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, no 0. The Senate insists.
House Bill 1069. The House has accepted the Senate amendments. House Bill 1099. The House has accepted the Senate substitute. House Bill 1261. The House has rejected the Senate substitute.
Senator Deeds, the senator from Charlottesville.
Madam President, I move that the Senate insist on its amendment and with great vigor, I demand a committee of conference.
The question is, shall the Senate insist on its substitute and with great vigor, respectfully, still request a committee of conference on the bill? All in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, no 0. The Senate insists. We have another one. Senator Surreville, the senator from Eastern Fairfax County.
Thank you, Madam President. I move that we waive the reading of the communication from the House of Delegates.
The question is, shall the reading of the communication from the House be waived? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, noes 2.
Ayes 37, noes 2. The reading of the communication from the House of Delegates is waived. The Senate will stand at ease. Fairfax County.
Madam President, I move the waive reading of the communication with the House of Delegates.
The question is, shall the reading of the communication from the House be waived? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 36, noes 3.
Ayes 36, noes 3. The reading of the communication from the House of Delegates is waived.
Unfinished business Senate, Senate Bill 556. The House insists on its amendment and requests a committee of conference.
Senator Saravel, the senator from Eastern Fairfax County.
Madam President, I was thinking about doing this in Spanish, but I will just... Can we do it in Spanish? No? Okay. I move that we accede to the House request for a committee conference so we can get out of here.
The question is, shall the Senate accede to the request for a committee of conference on the bill? All in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, noes 0. The Senate accedes to the request for the committee of conference.
Conferees on the part of the Senate is named by the Chair of Finance and Appropriations, Senator Lucas, or Senators Williams, Graves, Obenshain, and Saravel. Conferees on the part of the Senate on House Bill 14 is named by the Chair of Commerce and Labor, Senator Deeds, or Senators Eben, Saravel, and Peake. Conferees on the part of the Senate is named by the Chair of Finance and Appropriations, Senator Lucas, or Senators Lucas, Deeds, Locke, Boysko, McDougall, Pillion. Conferees on the part of the Senate on House Bill 30 is named by the Chair of Finance and Appropriations, Senator Lucas, or Senators Lucas, Deeds, Locke, Boysko, McDougall, and Pillion. Conferees on the part of the Senate on House Bill 590 is named by the Chair of General Laws and Technology, Senator Eben, or Senators Rouse, Aird, and Craig. Conferees on the part of the Senate on House Bill 790 is named by the Chair of Finance and Appropriations, Senator Lucas, or Senators Eben, Favola, and Pillion. Conferees on the part of the Senate on House Bill 960 is named by the Chair of Finance and Appropriations, Senator Lucas, or Senators Williams, Graves, Saravel, and Locke. Conferees on the part of the Senate on House Bill 1261 is named by the Chair of Commerce and Labor, Senator Deeds, or Senators Bagby, Deeds, and Obenshain.
Inquiry of the clerk. Does that complete today's calendar?
Yes, sir.
Committee time.
Is there any other business to come before the Senate? Senator Stanley, the senator from Franklin County.
Thank you, Madam President. I stand for a point of personal privilege.
The senator has the floor.
I know. Not very popular. But it'll be short, but I want to say thank you. Yesterday I had a medical emergency, a broken tooth, very painful. I had to come off the floor. I want to thank the people at the VCU School of Dentistry. They were willing to squeeze me in. They were very busy. They have faculty that work there. Dr. Formica took me right in. Of course, he had other patients there at the time. What a great staff that worked with me. I was there for about 4.5 hours. I looked better than I did going in. They did a great job. He's like the Picasso of fake teeth. But, and ladies and gentlemen, I want to make sure that you should appreciate the VCU School of Dentistry because they kept me quiet for 4.5 hours. Impossible. But they made the impossible possible. but they were so great, and I hope we all remember that. They're always here for us. VCU Medical Center is always here for us. I want to thank Kara Gunter and all of the people there. And also, you should go over there because I think something we need to prioritize maybe next year is that is the only school of dentistry that we have, and they need new building and equipment. And so that's something to talk about next year, but I want to thank them for the great job that they did for me yesterday to bring me back here today. Thank you, Madam President.
Chair recognizes the junior senator from Virginia Beach, Senator Rouse.
Madam President, rise for announcement.
The senator has the floor.
Ladies and gentlemen of the Senate, tomorrow is our basketball game. Tonight we do have practice, but it is optional. Tonight would just be a walkthrough to save our legs for tomorrow night. And we play tomorrow night at 8 o'clock at VCU. Our game is scheduled for 8 o'clock. So if you would get there an hour to 2 hours earlier, that way we can just have a brief huddle or conversation about how the game is going to flow. Thank you, Madam President.
Chair recognizes Senator Eben, the senator from Alexandria.
Rise for an announcement.
The senator has the floor.
The General Laws and Technology Committee will meet 5 minutes after adjournment to continue our docket. We've finished 17 bills, but we have 20 left.
The clerk will report any announcements on the desk.
Tomorrow, Thursday, February 29th, the Finance and Appropriations Subcommittee on Health and Human Resources will meet at 7:30 a.m. Senate Finance and Appropriations Room. Senators Deeds, Eben, Obenshain, Reeves, Favola, and Boysko. The Hampton Roads Caucus will meet at 7:30 a.m. in the House South Meeting Room on the 7th floor. The Committee on Education and Health will meet at 8:30 a.m. in Senate Room A. The Republican Caucus will meet at 11:15 a.m. Senate Room 2. The Democratic Caucus will meet at 11:30 a.m. Senate Room 1. And General Laws is right after adjournment.
Senator Saravel, the senator from Eastern Fairfax County.
Thank you, Madam President. Also rise for an announcement.
The senator may continue.
The Courts of Justice Committee has about 7 or 8 bills left, so we will also meet 5 minutes after adjournment, as fast as you can get there across the courtyard.
Senator Lucas, the senator from Portsmouth.
Madam President, I move.
The Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room A305. is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305.
All right, folks, let's get going. We're going to do this Sans patron. Oh, patron just walked in. Betsy Carr. Winner, winner, chicken dinner. Come on up to the podium. Tell us why people that don't pay their car insurance judgments should have a restricted license. House Bill 1082.
Thank you, Mr. Chairman, members, committee. 1082 simply authorizes the court to issue a restricted license for those individuals who have a motor vehicle-related civil judgment. Sarah Wilson from Drive to Work is here to speak to the bill.
I don't think we need in favor, but there's no opposition to it in the House, right?
No.
Okay. Anybody have any concerns about whether people that don't pay their judgments should be able to get a restricted license?
Move to report. Second.
Okay, Senator Stanley says it's a dumb rule anyway. Okay. I heard Senator Boysko moves and Carol Foy seconds. We report the bill. Clerk will open the roll.
You voted for me there.
Ayes 14, no zeros.
All right. Very persuasive,
Chairman.
Delegate Carr. All right. And we have no other patrons here, so
Delegate Carr, you want to hear some of your buddies' bills, or you want to explain for Delegate Simon, for example, or?
So McClure, you're waiting for Clark, right? Okay, so we got to do the Simon show next then.
Do you have any contested left?
Not really. So let's see, which assignments can we take up? Suicide's kind of heavy to do without him here. How about 1372? Sabrina, can you explain to us what 1372 does?
Yes, Mr. Chair. So essentially, HB 1372 is adding a knowledge-based authentication assessment to the methods by which an electronic notary public can obtain satisfactory evidence of identity of an individual. It also provides that notarial acts won't be invalidated solely because of a notary who failed to perform a duty or meet a requirement, but provides a remedy for an aggrieved person to invalidate that record or transaction.
Okay, so this requires somebody to take a test and get 80% on a quiz?
It's another method by which an electronic notary can obtain satisfactory evidence of identity. So yes, that is one of the options.
Mr. Chair,
Senator
I think it's a test like which of the following is an address at which you did not live, have never lived, which of the following is a person you have no association with. This appears to me to be a good bill. Unless there's any opposition or concern, I'd be prepared to make a motion.
Okay, is there any opposition to the bill anybody's aware of? Doesn't look at it. Came out of the House unanimously. All right, Senator Obenchain moves.
To report.
Stanley seconds. That we report 1372. Clerk will open the roll.
Ayes 14, no zero.
I still got you?
They list me as the chair of that, because I got your proxy.
Oh, you still have my proxy?
Yeah.
Okay.
Unless you wanted to vote differently.
No. Go.
So just having it signed is presented. He's going to
General laws stole our patrons?
Yep, general laws has stolen all of our patrons.
People think general laws is more important than courts?
That's just not right.
What is
Just have
wrong?
more bills left.
What is wrong with people?
McClure, where is Clark? Why don't we try and take up the homestead exemption one, 1339? Because I know there's some people here to speak to it. And my understanding is that Delegate Simon was going to propose an amendment to that, right? Is that in the packet?
That's correct, Mr. Chair, and yes, it is in your packets. Essentially, just in the enactment clause, it's changing from OES to the Department of Planning and Budget, the entity that will submit the new dollar amounts as required by the bill.
Okay, so Deeds moves, Boysko seconds the line amendment to the enactment clause. Yep, you did. That will have the I guess the Department of Planning and Budget will be doing the CPI calculation instead of the Executive Secretary of the Supreme Court. All those in favor say aye. Aye. Anybody opposed? No. Okay, so Sabrina, tell us what the bill does now.
Sure. So, Mr. Chair, HB 1339 adds into the code for both the homestead exemption and the poor debtors exemption the requirement that beginning on April 1st, 2027, each monetary limit will be adjusted to reflect the change in the consumer price index for urban consumers. So essentially that just means that the code, it's now codified that the numbers will be adjusted for inflation instead of doing it legislatively.
Sabrina, how are people supposed to know what the number is every year? Where do they go to find that?
It is the Consumer Price Index for all urban consumers as published in the Bureau by the Bureau of Labor.
Sabrina, that's not what I'm asking. How do you?
Oh, it's codified.
In like 2029, where do I go look to see whether it's $52,000 or $55,000? Do I have to do the calculation every year? Is somebody going to publish it online?
Oh, no, I'm sorry, Mr. Chair. It'll be calculated by the Department of Planning and Budget, which is the line amendment.
And where are they going to put it so that the attorneys know what number to put down in the document?
Mr. Chair. I think,
Okay.
Mr. Chair,
Sabrina.
it'll be codified at that point and changed, I would assume, by the Code Commission.
Okay, cool. So why don't we take, I know there's some supporters out there, why don't we take the supporters through 3 and 3, and maybe they can help with that too. Come on up.
Those online who would like to speak in support, please raise your hand electronically.
3 minutes. Yep.
Good evening, Mr. Chairman. Dan Press on behalf of the Virginia Alliance of Consumers and Bankruptcy Attorneys. This is a compromise bill that we worked out between ourselves with the agreement of the bankers and the creditors bar. In addition to the indexing, which would mean we don't need to come back every few years to, play with these numbers, it increases the homestead exemption from 25 to 50.
Counsel, can you answer the question I asked?
I'm sorry.
I'm not a bankruptcy lawyer, but every once in a while I have to do a judgment. Where do I go look to find the number?
Oh, that's easy. You go to the Code Commission. So the Department of Management, or whatever they're called, it was going to be the Executive Secretary. They report that number to the Code Commission, and the Code Commission publishes it in the code.
Okay, so every year the code's going to get updated.
The code will be updated by the Code Commission every 3 years.
Okay, this is a compromise. There's peace in the valley. Everybody's good.
There's peace in the valley with the all the relevant constituents.
Okay. I think Senator Deeds has a motion.
I move to report.
Okay. And then Senator Boysko moves to report. And Salim seconds to move to report the bill.
Yes.
Okay. Okay, clerk will open the roll.
Ayes 14, no zero.
Great. Thanks, MJ. Clark, are you guys ready yet? Do you have a draft for us?
Yes. There is a substitute, amendment in nature of a substitute.
Hold on, Clark. So we got 351 and we have 158. What do we got?
And if
Taylor, you want to tell us what we got?
Yes, Mr. Chair. So there is one substitute that's been distributed to everyone that is a substitute.
Sorry, can you speak up again?
I'm sorry. There is a substitute that has been distributed to everyone for HB 351 already, and there's going to be some additional changes to that substitute. So,
351's in the package, Mr. Chair?
yes, it should be in the packet, but there's going to be some additional changes to that as well that I've printed some informal copies with the additional changes that I can pass out to the members, but I can also just work off of the substitute that's been distributed as well. So a few things that are different in the substitute are that it took out the penalty of perjury that was previously in the bill for if someone filled out the certification statement saying that they did not live with a minor. Previously, that was under penalty of perjury, so that's been removed. Also, when it is talking about a person purchasing a firearm, they have to purchase a locking device if a minor is present in such person's residence for 14 days or more in any calendar month. And the bill also added the language that also appears in Delegate McClure's bill about when a licensed manufacturer, importer, or dealer is selling to someone, selling any firearm, then the firearm has to be accompanied by a warning that goes over safe storage and talks about any civil or criminal liability. And then there's going to be some additional changes where the penalty is going to be changed to a Class 3 misdemeanor. Originally was a Class 1 misdemeanor. And also some slight tweaks in the language. If you're looking at the substitute on line 20, it's going to now read, any person who purchases a firearm shall either obtain or purchase from a licensed dealer a locking device for such firearm, and it would go on. And then that same change on line 33, where it talks about and the transferee, and it would read obtains or purchases a locking device from such dealer. So that was supposed to capture if the locking device is provided by the dealer. So it doesn't read that the person just has to purchase it. So if it's provided by the dealer, they've obtained it or they can purchase it. Yes, that's going to need to be an additional change adopted by the committee. So the substitute as distributed had it as a Class 1, but it should be changed to a Class 3.
Okay, I'm sorry, Taylor. So you're saying we need to adopt the sub first, right? Okay,
Yes.
Senator Dees moves, Boysko seconds to adopt the sub to House Bill 351. All those in favor say aye. Aye. Okay. Now, the sub is before us, and you're saying there's another 3 changes or 4 changes to it?
Yes, that's right. As you noted on line 41, Mr. Chair, changing that Class 1 to a Class 3 misdemeanor.
Right.
And then also that language previously noted that would be on line 20 that adds right after the Romanet, obtain or purchase from a licensed dealer, and then the same language on line 33.
Senator Boysko.
Thank you, Mr. Chair. So we have just passed another bill around safe storage that requires that any firearm that is in the home with an adult who is prohibited or a child be locked, and it could have a biometric device if the ammunition is stored together. I'm just wondering if council feels that this is in any way in conflict to the other bills that have already passed through, or if this goes in tandem, just so we're just thinking through this before we make a decision.
Yes, Mr. Chair, Senator Boysko, the safe storage bills would address conduct for how someone stores a firearm at their house, and it said that they have to store it locked in a locked container when they know that a minor or someone else prohibited by law from possessing a firearm is present. This bill is addressing at the time someone is purchasing a firearm that they're going to need to purchase a locking device, and it's going to need to come with a warning. So this is kind of at the time of purchase of the firearm. The other bills are addressing how they're stored at home.
Mr. Chair, I know that in the bill that was the safe storage, there was a provision that said that the dealers have to have a sign on their doors, on their windows, that state that the provisions of the bill that we have already passed through here. So would this be an additional warning? That I do think it is in conflict. I don't think it's exactly the same. And
This is a piece of paper that comes with a gun and not a sign.
Okay, thank you. But it still is a little bit, I'm not trying to mess with the bill. I just want everything to be consistent. I like the concept of it. I just want to make sure that we're just both of them are on the same page.
I think this one has more to do with purchase, and yours has to do with ownership once you have it.
Mr. Chair.
Yeah, Taylor.
And Senator Boysko. Senator Boysko is correct. Her bill does include provisions, but as you noted, Mr. Chair, it's a notice that will be posted at the premises of the dealer, and it's kind of drawn towards any person who possesses a firearm when they know the minors in the home or there's another person prohibited by law, how they'll store the firearm. And this warning that comes with the firearm is talking about the locking devices. The use of locking device or safety lock is only one aspect of responsible firearm storage, so I think they kind of both address the conduct that each bill is prohibiting.
Sorry. Oh, Jordan, your question?
Mr. Chair, is state police in the audience?
Sorry, what's the question?
Is state police in the audience? They're referenced in the bill, that's what I'm asking.
I don't see state police out there.
Maybe this is a question for council. Mr. Chair.
Go ahead, Senator Jordan.
To council. In years past, when we have promulgated state police to do forms, it doesn't really prescribe in the bill, but if one has to certify under penalty that there's no minor residing in the home on a form to a state agency, would it also be required, would one think, or is the intention of the bill patron, maybe I can direct it to him, also to list minors and their ages that are in a home? And if so, how would an agency store that? What would be the proper way that, I guess, that would be tracked?
If I understand, Mr. Chairman, Senator Jordan, if I understand the bill correctly, in its current form, this is not a certification to law enforcement. It's a certification that must be completed in order for the purchase or the transaction to be lawful.
Follow-up.
Senator Jordan, go ahead.
Follow-up question, Mr. Chair. So in the substitute that we're looking at, it says the form to be provided by state police. So in years past, when we have had forms that are required to be provided by them, or do we list names? Do we just do a checkbox for minor present? Do we have any form like this currently?
Mr. Chair?
Yeah, go ahead,
And
Taylor.
Senator Jordan, I don't know if this will exactly answer your question, and I don't want to speak for state police, but in the fiscal impact statement, it looked like state police noted that they would, it sounded like they felt like they could update the current V-check forms. So I imagine it's possible that they could just add a question on those forms for the person to fill out whether a minor is present in such person's residence for 14 days or more. So just perhaps adding a question to the forms that they already have the criminal history check.
Mr. Chairman, follow up that to council. I mean, are these statements, if they add to the statement that we fill out when we're purchasing a firearm, are they foiable? I mean, can someone find out whether a child of this age or younger lives in my house more than 14 days in a calendar month with my name and address on it?
Why not? It's a public document.
It's a public document. I mean, which is dangerous.
I don't
in
see anything
today's
in the
world.
bill that requires the state police to keep the document. They provide it to the fireman, the seller, and then the seller, it looks like the seller keeps it.
Well, then we don't need any of that stuff that your license plate readers require them to get rid of it.
Right, counsel, am I right? I mean, it doesn't say the state police is going to be the custodian of this document. It looks like you just have to provide it to the seller when you buy the... Right, the state police publishes a form, and then the form's filled out when you buy the gun, you give it to the person that's selling you the gun, and then they keep it with their records to show they comply with law, right?
Mr. Chairman, having purchased firearms and having represented people who have written on that document, when that document, they fill it out, the state police, that information at the very least is transferred to the state police, because I've had clients who have then been investigated by the state police at their house and residence that they filled out the form wrong and then
Right,
arrested.
Senator, I think that's part of a NICS check. Senator Perry, I think your light's up. You have something
Yeah,
to say?
the state police keep those forms, right? That's how we get them whenever you prosecute the cases. State police bring them to court. So I would expect that they would be keeping this form as well, because I don't know why they wouldn't be, because if you're going to prosecute the case, we need it in the custody of law enforcement.
Okay, maybe I'm wrong. Senator Boysko?
Yeah, Mr. Chair, thank you. I just went back and looked at what the required law that we're working on passing, waiting for the governor to sign around the storage, which is a firearm may be stored and loaded provided that there is a biometric storage device. And here we are requiring that the gun have a firearms should be stored loaded, unloaded, and locked in a separate from their ammunition, which is different. And I just feel like they need to be
And
consistent.
I believe, is that the current?
Senator Delegate Clark.
Oh, thank you, Mr. Chair. I believe currently that is how you have to store your firearms in your homes. Is you have to make sure your ammunition is separate from your gun, from your firearm.
What?
Oh, okay. Oh, okay. Maybe that's in your car. You have to have it separate.
Yeah, guys. Yeah, hold on, guys. Try and go through the chair here. So, is there another question? Peek, you got a question?
Well, did council ever answer the question? There is a form. It's sent to the state police. The state police keep the form. Is the form foilable?
Mr. Chairman, I have no idea.
Sir?
I have no idea.
That's kind of a, Mr. Chair, then I think that's a big problem. That's a very big problem. Publicly kept document. And if then it can be discovered by FOIA and find out what minor children are living in your house.
Okay, well,
that seems like a major invasion of privacy.
Senator, first of all, we don't have the state police here to answer any questions. We seem to have a difference of opinion about it. Maybe I'm the outlier, I don't know. But we have a bill now that I think Senator Boysko's concern conflicts with her bill.
Right,
and we don't have time to be doing a lot more surgery on this tonight. It seems to me we need to slap reenactment clause in this thing, send it out of here and put it in conference, and then you guys can go try and figure it out over the next week if you want to have a bill to work with. Or we can just vote no. That's right. So what does the committee want to do? Who wants to make a motion?
Mr. Chair, how about we put a reenactment clause so that we can
Okay,
get
Senator
it into
Boysko.
conference? And I move we amend it to do that and then make a motion.
I'll second that.
Okay, Senator Boysko moves to put a reenactment clause on it. Let's do that first, then we'll get to more questions. All those in favor say aye.
Aye.
Aye. Anybody opposed? No. Senator Stewart.
I want to ask Mr. Benjamin a question, if I may, because he knows more about this than I do. Could these forms be used to cross-reference people who, for instance, want court-appointed counsel, and they have to make certain statements to a court regarding people or dependents in their home? Do you have any concern that there could be some interplay between these forms because they are government agencies that work together? You understand what I'm saying? Asking?
Nothing, Mr. Chairman, nothing triggers any concern on my part about those two forms, unless the question is if affidavit of indigency has whether you have dependents on it. Correct. And this would be a certification that you don't have dependents.
That's my question.
So, Mr. Chairman, Senator Stewart, if a law enforcement officer noted a discrepancy in those two forms, that could form the basis of a prosecution. A more realistic question is this. Mr. Chairman, we took out the requirement of under oath because we didn't want to set somebody up for a prosecution for perjury or a false statement on one of these forms.
Actually, it was to avoid a fiscal impact, but go ahead.
Well, there was that too, Mr. Chairman. But if somebody made a false statement that they didn't have minors in the home in order to acquire a firearm, that could still be charged as a fraud. False pretenses under 18.2-178. But, Mr. Chairman, that's why we tried very hard to make it specific. Instead of just resides, that's why the substitute says that you have to certify that a minor isn't present in your residence more than 14 days in a calendar month, just to try it, resolve any ambiguity.
Okay, Senator Stewart, you done with your question?
I'm done, yes.
Okay, I think we also haven't made the amendments that Ms. May suggested.
Mr. Chair, I will move those amendments.
Senator Deeds moves, Boysko seconds the additional line amendments to the sub. All those in favor say aye. 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 Anybody opposed? No. Okay. So now we have a bill with a reenactment clause on it that's going to need more surgery as it moves along. Any further discussion, questions, debate? No? A bill that does nothing has to go to finance now. All right. This one has to go to finance still?
It's a fraud.
We took the felony out of it, so we didn't have to go to finance.
Council just said that it creates such.
Hold on, guys. I can't hear anything. Okay.
Last three. So I'll move to report and refer to finance.
Okay. Senator Deeds moves. Boysko seconds that the bill is going to be reported and re-referred to finance at 9 a.m. tomorrow. Clerk will open the roll.
Ayes 9, no 6.
Okay. Thanks. McClure, your carryover?
Sorry?
We carrying you over?
No, now that they're not in conflict, I'd like to present the bill to you, Mr. Chair.
Okay, let's then turn to House Bill 158. What are we going to do to your bill? Because I thought we just put your warning into his bill.
Mr. Chair, I mean, if you don't like the warning piece, since it's in his bill, we can take the warning piece out. But the other part about requiring the licensed firearm dealers when selling or transferring the firearm and providing that locking device, that's still in my bill. So HB 158 requires, yep. Mhm.
So you're not proposing any amendments to your bill?
No. So we made the amendments to his bill so that they wouldn't be in conflict. So with his, it's either obtain or purchase. And so obtain meaning that the firearm dealer could provide the lock.
Okay. So what does your bill do now?
So mine requires licensed firearm dealers when selling or transferring the firearm to provide a locking device. And then it also has that include the specific warning that firearms should be locked and kept away from children, and a warning that there may be a civil or criminal liability for failing to do so. But if you don't like that it's also in his, we can strike that language from mine and just keep the portion about requiring the licensed firearm dealers to provide that locking device when selling or transferring a firearm.
Which one of you wants to go first?
Mr. Chair.
Senator Boysko.
I would just say that it's the same problem with the consistency of the bills that have already passed through both bodies that I would be concerned with as far as the notification and the warning.
Mr. Chair, I'm happy to strike that language about the warning and notification, and just keep the portions in there regarding the licensed firearm dealers providing that lock.
Okay, so you want to strike Section B?
Mm-hmm. Yes, Mr.
Okay,
Chair.
Senator Boysko moves, Deeds seconds to strike Section B. All those in favor say aye. Aye. Anybody opposed?
And Mr. Chair,
Yeah.
just it wouldn't be all of subsection B. It would just be on line 23, starting after that first instance of firearm, just striking where it says, and the firearm is accompanied by the following warning.
Oh, my bad. Okay, we'll just pretend I made that motion. Okay?
Mr. Chair, through the end of 29.
Right.
Yes.
Right.
That is correct, Mr. Chair.
Yep. Okay. Got it. Okay. Senator Boysko, any other conflicts?
Mr. Chair, I'm not saying any conflicts. I'm just trying to understand what the difference is between the two bills.
Mr. Chair, so mine at the point of sale or transfer would require a licensed firearm dealer to provide the lock. With Delegate Clark's bill, his would require either they obtain one, which is provided by the dealer, so if mine ends up getting signed or not, it wouldn't impact his bill. So it's either obtain or purchase. And so that the obtain is what keeps us out of conflict.
Mr.
I'm
Chair.
not sure we see it that way.
Mr. Chair, I would
Senator Boysko?
I would suggest that if one bill says that the salesperson has to provide it, and then another one says that either you could have the salesperson provide it or you can get it yourself, I think that does leave us in conflict.
Right, that was the conflict I was worried about.
That seems a little bit confusing and probably not good policy for us to pass both things. Not to be unkind, but we want to have good policy.
Okay. So where does that leave us? Because I thought this was going to get incorporated into Clark's bill, and then we're only going to have one bill going forward because of this specific conflict.
Such similar bill.
Right.
So, Mr. Chair, mine specifically is at the point of sale for making sure that the firearm dealers do provide the lock, but they are standalone bills.
They're standalone bills, but they put the burden on getting the lock on two different people at the same time. We can't legislate both solutions. That's why we're.
But
in
currently,
conflict.
certain dealers do provide a lock. Certain dealers do provide a lock. So with his language, having the obtain or the purchase, it just depends on whether or not there's a lock provided.
Okay. Somebody needs to make a motion. Okay. Motion reports the primary motion. Open the roll. Huh? Move to report. Open the roll. Yeah, there was a second. Salim second.
I'm a reaper.
So the motion's withdrawn? Okay. Motion to carry over is the primary motion. MJ, can you open the roll?
Ayes 15, no zero.
Thank you, Mr. Chair, members
All right.
of the committee.
All right. Thank you, Delegate. Simon, you're the only thing standing between us and dinner. And we have passed two of your bills. Your two remaining ones are suicide and foreclosure subordinate mortgages.
Do they also have notaries? Did you guys do notaries?
We already reported that out.
I do better when I'm not here. Maybe I should leave.
No, we thought these were a little too heavy to do without you.
All right. Which one do you want to start with?
81.
All right. So, Mr. Chairman, members of the House, so I have I think I have some line amendments that if somebody
Yeah,
would move.
you do. Senator Deeds moves and Boyce goes seconds. The line amendments are from the very front of the stapled package. All those in favor say aye. Aye. Anybody opposed? No. Okay, tell us what your bill does with the line amendments.
Okay, so with the line amendments, so what this bill does is abolishes the common law crime of suicide. So under Virginia law, we have no codified law against suicide, but under by bringing in the common law, where suicide is considered a criminal act, it's a misdemeanor in Virginia right now to commit suicide. So this statute would abolish that common law crime. What the amendments do is they provide a delayed enactment so that this won't become effective until July 1st of 2025, and then directs the Bureau of Insurance of the State Corporation Commission to review the effect and implications of the abolition of the common law crime of suicide on insurance and life insurance policies throughout the Commonwealth, with the idea being that we'll have, and they'll report back to the chair of courts of justice in the Senate and the House on any implications by November of 2024, so that we have next year's session to make any adjustments or changes that, as a result of their study that would result from this.
Right, you do that because every time this has come up, from when Delegate Grupika carried it all the way through and Delegate Corey carried it, everybody always says they're worried about how it might affect insurance, and so you're putting that in there to get it some answers on it finally after 7 years or something, right?
Yes, that's
Okay.
correct, Mr. Chairman.
Okay. Any other questions? Did you have opposition last time?
Not in the, well, there's
All
some,
right.
yeah, there's some opposition.
Okay. Catholic Conference, I see you guys are here. Is that why you're here? No? Nope.
Those online who are opposed to the bill, please raise your
Okay.
hand electronically.
Okay. Let's see if there's any opposition. Doesn't look like it. Caruso, you're not in opposition? Nope. Okay, got it. All right, Senator Perry's moved to report, second by Boysko. Clerk will open the roll.
Ayes 10, noes 5.
All right, last bill of the year.
Last bill of the year.
This
Chairman,
one's got a little bit of heat on it.
Yeah, this one's got a substitute, I believe.
So everybody can turn to House Bill 184, sub in the packet. Senator Deeds moves, Boysko seconds to adopt the sub. All those in favor say aye. Aye. Anybody opposed? No. Okay, sub is now before us. Tell us what your sub does.
All right, so Mr. Chairman, members of the committee, what this substitute does is this bill targets a practice of debt buyers. So around 2008 and 9, as you all know, there was a real estate crash. A lot of people got underwater. They worked out deals with their mortgages, and they got their second loans frequently were charged off. And so they worked something out with the bank. The bank stopped trying to collect on their debt, and the homeowners assumed everything was fine. They went about making their payments on their primary mortgage. They never receive any bills, never receive any collection efforts on their second mortgage. A debt buyer buys that second mortgage, and all of a sudden now, 10, 12 years have passed by. They've been doing everything right, and these debt buyers come and try and foreclose on their property to steal the equity in the property under this debt that they bought, even though the homeowners never received any bills or any efforts to collect on the mortgage. So this substitute says that if you're going to do that, if you want to foreclose on one of these second mortgages, the first thing you have to do is provide evidence that you've actually been trying to collect on it in the form of an affidavit, and then show some evidence and certify that you've actually been doing that. We worked this out with the creditors bar and some consumer advocates who have been proponents of the bill. Right before we were trying to do this on, I think, one of the first meetings, the bankers came in and said they had some concerns. We've done our best to try and address their concerns. I think there's one sentence in here that the bankers still don't like, so they're going to tell you that they're opposed to the bill. But other than that one sentence, we have pretty much consensus across all the stakeholders.
Okay, MJ, any questions for Delegate Simon before we take testimony?
Mr. Chair.
Senator Jordan.
Thank you, Mr. Chair. Delegate Simon, I don't mean any harm to your bill, but I do have a question. Do you see any concern or possibility that this can open up kind of like a problematic situation of us opening back up subprime lending and things that were happening a lot in the 2008 to 2011 range? Because that's my concern that I see here with the bill.
So, no, I don't see any possibility of that. This is, again, all this requires is that if you're going to foreclose on somebody's mortgage and take their house, you've got to provide some evidence you've actually been trying to collect on the debt and that you've been sending them bills, they haven't been paying them, there have been interest and fees. So I don't think this would encourage any bad actors. In fact, this is meant to do just the opposite. It's meant to deter predatory lenders and predatory debt buyers from trying to steal people's homes.
Follow-up question, Mr. Chair.
Go ahead, Senator Jordan.
Thank you, Mr. Chair. Delegate Simon, what I'm trying to get at is that when this person tries to, after, obviously their credit has been affected, when they go to attempt to obtain a future mortgage within a certain amount of years, I'm fearful that this is going to open up, a subprime situation of predatory lenders towards people that have poor credit. Do you not see that same concern?
I honestly, I really don't understand how this bill could get you to that conclusion. No offense, I don't understand how you'd get there. This is people that have been paying their bills, rebuilt their credit, established some equity in their houses, and we don't want somebody to foreclose if they haven't been trying to collect on the mortgage actively.
Any other questions for Senator Simon before we move to testimony?
I got a promotion.
What?
Delegate Simon.
I'm glad you recognized. I'm sorry.
I've never made that mistake before. I don't understand how you could possibly do that.
Sorry about that. Chair. Yeah, Senator Obenchain has a question for you.
Yeah, can you walk me through exactly what A2 means on page 3?
All right, Mr. Chairman. So if you are going to be the purchaser, so A2 is, so if you're the buyer at a foreclosure sale, you've got to go pay off the first mortgage. So the situation would be you did an 80-20 mortgage back in 2005.
Mr. Chairman, hang on one second.
Senator Obenchain.
So would the first mortgage be the priority security instrument?
Yeah. So your first mortgage would be your 80% mortgage.
Referred to in line 71. So it says any priority security instrument, so it would mean something more than just a primary mortgage, wouldn't it?
Well, so anything that's first in line, right? So whoever gets to the courthouse first has priority. So that's a priority security instrument. So if you're buying, because typically the way this works is you're buying a second mortgage, a home equity line of credit or some secondary mortgage. And if you're going to buy that, if you're a legitimate buyer at foreclosure, then that triggers the due on sale clause typically on that superior mortgage instrument. And so we want you to go ahead and pay that off, because that's the idea is you're buying the house at foreclosure. You need to then pay off that mortgage, because what's happening is if you don't, the homeowner whose equity you just foreclosed on, they're still obliged to pay that first priority mortgage. So they're still making mortgage payments every month on a mortgage for a house they no longer own because somebody foreclosed on the second mortgage. So we're saying if you're going to foreclose on somebody's house and take title from them, and there's a priority mortgage there, You need to pay that off quickly so that they stop having to make payments on a house they no longer own.
Mr. Chairman.
Senator Stewart.
How do you foreclose on a second mortgage when the first mortgage is still in existence and still standing? You can't do that.
No, you can't. That's
No, you
again,
can't.
that's part of the problem this bill's trying to solve.
You still have a priority instrument.
Right. So
exactly. You can't foreclose on the second
guys.
unless you
Wait.
pay it off.
We're not going to have a debate here. Go through the chair.
So, Mr. Chair, you take, when you foreclose like that, you take title to the property subject to the superior instrument.
Right.
So now it's still a lien on the property. You can't sell the property to somebody else till that lien's paid off, but you can hold on to it. And what this bill says is that you have to pay it off within 90 days so that you don't keep the original homeowner whose house you just foreclosed on having to pay the mortgage on a house they don't own anymore, that you own.
Okay. I think there's also somebody online that can answer some of these questions as well.
Probably better than me, I'm sure. I was
Why don't we
I'll
take
phone a friend.
testimony? Why don't we set it 3 and 3? I believe there's somebody online that wants to testify in favor of this.
If you're online and would like to speak to the bill, please raise your hand electronically. I'm bringing them into the room, Mr. Chair. Christy Kelly, you may unmute, turn your camera on, and speak to the bill.
Christy?
Can you hear me?
We can hear you now.
For some reason, my camera is not working. It's not letting me turn it on. But can you hear me?
We can hear you. Go ahead, Christy. We know who you are.
All right, I'm sorry. Thank you, Mr. Chairman and members of the committee. I just want to clarify that Delegate Simon's bill does not prevent the foreclosure of a second mortgage for the amount of the note. But what it does prevent is the retroactive assessment of interest and fees where a consumer has not been notified of those accruing interest and fees for the past decade when they weren't in communication with the homeowner. And so it essentially prevents the robbing of equity. And I'm sorry, I have children in the background here, but it prevents the robbing of equity from homeowners. It does not prevent banks or other reputable companies from foreclosing on their second mortgage if someone hasn't paid. It just prevents them from not assessing bogus charges and interest when they don't know it. I have litigated these cases now the past 3 years. Some stories, these debts are sold. I have a client whose debt was sold for 67 cents for a $70,000 note that was discharged 12 years earlier. And then he was told unless he pays nearly $200,000, his home will be foreclosed on. He was current on his first mortgage and had not heard any communications from his second for more than a decade. I was recently contacted by a legal aid organization for assistance for another homeowner, an elderly widower whose husband took out a loan. They owed about $12,000 on their loan. They were foreclosed on in January. She's still paying her first mortgage because they have not paid off her first mortgage. And she didn't understand her rights and what her options were. She didn't even know there was still a second mortgage because she thought that her second mortgage had been satisfied when they refinanced their home. And apparently it wasn't. But this does not affect reputable companies and banks. It's essentially preventing debt buyers who can foreclose without any oversight or any court intervention. Debt buyers have far more restrictions in Virginia now to sue on a credit card debt than they do to foreclose on someone's home. Many homeowners...
Ms. Kelly, your time's expired. You have to wrap it up.
All right, sorry. This just prevents the disclosure of unlawful fees and charges and stripping of equity from homes. People can still foreclose if people don't owe debts. It's just making sure it's a fair process. Thank you very much.
Okay, thanks. Anybody else here in support? Poverty Law Center supports? Anybody else? No? Okay, opposition, come on up, reset. Somebody have a question for? A question for Ms. Kelly?
The people y'all are using the phrase stealing the equity from the home. I mean, the person who's living in the home signed the documents to give the second mortgage, correct?
So, Mr. Chairman, I would say to Senator Peake, and I appreciate Ms. Kelly for coming to clear this up, if I overstate the case. If you took out a $100,000 home equity line of credit and they foreclose, they can come to you to make a demand that you pay that $100,000 back.
Well, which they do if I don't pay.
What they can't,
Mr. Chair, but yeah, so I take out the loan, I'm supposed to pay it back. So I know, Mr. Chairman, that I'm not paying it back, so then they foreclose on it. So, so now, Delegate, where do we go from there?
No, I said that, and they can do that, and they can get their $100,000. What they can't get is they can't charge you interest and penalties and fees for the period where they were not sending you any bills, they weren't actually actively collecting it, you weren't getting any statements, you had no idea that interest and fees were still accruing because you'd been told that it had been charged off or had been written off or that they'd given up on trying to collect it.
Mr. Chair, yeah, how in the world do you get told that your second loan, your home equity line, has been written off and charged off? In the real world does that happen?
Ms. Kelly can probably has some of the real world examples if we can bring her back. I'm sure she could tell you. But one way you could have it discharged in a Chapter 7 bankruptcy, so they don't release the lien, but they discharge you from the debt, so it gets discharged that way. You could have you worked out a modification, but there are a number of things that happen that cause them to stop trying to collect it and tell you that they're not coming after you.
Charge-off happens all the time, Mr. Chairman.
Mr. Chair, so you declare bankruptcy, Mr. Chair, so you declare bankruptcy, but they don't let you out of the loan?
Well, they let you out of the loan, but they don't let you out the lien.
Right. They let you out of the loan. They can't sue you for the balance for the loan, but the lien is still attached to the house.
But
Stanley, you had
Mr. Chairman, a quick question, which kind of brought by somewhat of what Senator Peake said. So if I buy there's a second on a house, and I buy it, and then they don't pay me and I foreclose, how am I going to prove that the person that I bought it from or the bank that I bought it from gave notices every month? I mean, and if I don't have that information, am I just basically tattooed on that?
No, you can foreclose and you can get paid. At your foreclosure, you can get out of the equity of the house the note amount, the amount of the note. What you can't get are those interest and penalties for those periods where you can't prove that somebody was ever trying to collect on the debt.
Right.
I'd like to have debt. Nobody.
Okay, why don't we go to opposition? MJ said it. What did we do? 3, was it? Yeah.
Mr. Chairman, members of the committee, Matt Bruning with the Virginia Bankers Association in opposition. The substitute before you is vastly different than the bill that passed the House. I do want to acknowledge with appreciation the willingness of Delegate Simon to engage with us on the language and certainly try to hear out and address some of our concerns. Unfortunately, we weren't able to get completely comfortable with the final result before you today. We certainly understand the situation the bill aims to address, but believe those rare instances by bad actors require a more tailored approach. It's an issue requiring a scalpel to remedy, and I fear this, what we have before us today, is a sledgehammer. Lenders make a loan expecting and wanting to get paid. That's our business model. Foreclosure is the process is something we don't want to go through and is really a last resort, especially when the bank is not in the first deed of trust holder and in the subordinate position as contemplated in the bill. Adding complexity and obstacles to that process gives additional pause to lenders to make access to credit available, potentially diminishing availability of those types of loans, which includes HELOCs, second mortgages, refinance mortgages from regulated lenders. Specifically, we remain concerned about requiring an affidavit asking the lien holder to attest to knowledge of actions not only of them, but that could have been the responsibility, as Senator Stanley pointed out, of a previous lien holder that the current lien holder might not know or be able to confirm. Totally new, and as Senator Obenshain pointed out, an A2 provision at the end of the new language in the bill establishes a time restriction on a purchaser after a foreclosure sale to satisfy all other existing priority liens. This requirement could depress purchaser interest in the sale, applying downward pressure not only on the sales price and then the ability to ultimately harming the borrower and covering their outstanding debts, but also in the overall property value. Again, we appreciate some of the changes the Patriot incorporated into the substitute that you've adopted, but there are too many remaining concerns and unintended consequences in this very, very broadly applicable bill. It's still a sledgehammer, and we need the scalpel. We respectfully ask you to oppose the bill.
Mr. Bruning, you would agree that the main source of the problems that we've heard described are debt buyers, not banks.
Correct. But I mean,
you would agree that often what happens is the banks they put a second HELOC on somebody's house, and if somebody starts taking out money on it or goes delinquent, the banks basically sell it. The banks don't actually try to collect these. It's usually some third-party debt buyer that's bought these things for like literally pennies on the $100, right?
Mr. Chairman, that is something that banks do, but they also hold it on their books and collect it themselves. They service the mortgage, and the subordinate mortgage. They service HELOCs. Community banks, large banks do it too. So it is a practice, but it's not the only option for the financial institution.
Okay. Are you aware of members of your organization that charge off debt? Somebody stops paying, they charge off the debt, they stop sending them statements, and then years later sue for it or foreclose for it?
I'm not aware of any instance where that's occurred, but again, putting these requirements in there to set up one more kind of challenge and burden and trap, so that we have to go through the court system to prove that. And again, even banks buy other portfolio of loans from banks if they want to, get their, mix right. So it could be a bank attesting that another bank did something that they don't have any knowledge of.
Got it. Okay. Thank you. Is there anybody else in opposition? Doesn't look like it. Delegate Simon. Final word.
Final word to Senator Stanley's question. If you are doing your due diligence before you buy $100,000 debt, you're going to find out if they've been sending bills. What are my options for foreclosing on this? And then you discount the price for the unknown things, right? So that's already sort of baked into the purchase price. I'm not terribly concerned for those folks that buy up these second mortgages not knowing whether any bills have been sent or not, and then don't know if they can attest to these things or not. In fact, I think those are exactly the folks we're trying to prevent from doing this. And for the banks, I understand their concern. We worked really hard to get to somewhere that they could support it, but I think they really don't have anything to be concerned about, because all the banks I know that service loans send bills and they send statements, and when you get behind, you hear from them a lot, and they let you know that it's racking up. Here's all the interest, here are the charges, here are all the attorney's fees you're liable for if you don't start paying us soon. So they'd be fine under this bill.
Okay. Senator Peake.
Speaking to the bill, then
Go
we're
ahead.
at that point. It's based on what I can discern after reading this substitute in this short a time, you're a homeowner, you get a home equity line, you quit paying the home equity line, you just quit, you quit paying any payment, you quit paying any interest, you go for a number of years without making any payments, you've borrowed the money, you've used that home equity line, you've gotten the money, you've used it, and then sometime down the road, somebody comes back and says, hey, you still owe me the money that you borrowed, you got the line of money from, you got it, you spent it, you still owe it, and then you're mad, and this bill will protect you from having to pay the money back that you borrowed, that you knew you borrowed, and refused to pay back. And so if that is wrong, let me know, but that seems to be what's going on, and I think it's a bad bill.
Well, Senator, part of the problem, I think, is that federal law requires you to be invoiced monthly if you're owed money. And when these companies charge off debt, they stop issuing their invoices, and these consumers think they don't have a debt anymore because they haven't gotten an invoice in 5 years. And that creates the problem, and that's what this is trying to fix. They're violating federal law, and then they come to Virginia and collect on their loan. That's what happens.
And they can still get their, Mr. Chairman, they can still get their original principal back. I mean, they can still get the note amount back. It's just those extra fees and interest that accrued why they weren't getting bills that are excluded.
Any other thoughts, discussions? No? Okay, it's moved and seconded. The bill be reported. Any further discussion? Clerk will open the roll on our last bill of session.
Ever.
Ayes 8, no 7.
All right, you are on the dance floor, but with a little bit of a fever. All right, committee will rise, folks. Good year.
The Senate of Virginia, Richmond, Virginia.